Oh, yeah.
Milord, could I mention, Milord, an application, Milord, which is appearing in your Lordship's list, Milord? Kindly recollect, Milord, while your Lordship was in the Milord Andaman Circuit Bench, but I had mentioned a matter, Milord, from the principal bench, where, Milord, the Honorable Division Bench had directed that you go and file an application for review before the learned single judge. My Lord was pleased to grant me leave, Milord, virtually. Milord, the application has been filed. But it's appearing in your Lordship's list, but it could not be reached, Milord, by this time. The appeal is pending before the Honorable the Chief Justice. This was taken up, Milord, this week. Milord, the Honorable Division Bench was pleased to request me to personally mention this matter so that your Lordship may kindly give some precedence to this matter. And the appeal is to come before the Division Bench on Monday. But I don't think it can be taken up by Monday. In the next week, any day, if your Lordship may kindly accommodate me, Milord.
But then I accept mentionings for upgradation on regular basis on the first Monday. So nobody mentioned it.
Yes, nobody mentioned it. True.
Then
Milord, I'm told,
more than 100 pages list.
Oh, Milord, I'm told, Milord, I did not have this information. I'm told that the other side, that is the writ petitioner, had mentioned last Monday.
And
I'm told.
the mentioning has been allowed. Are you aware of it?
On being allowed, it is item 288.
Of the daily list.
Yesterday's list. Yesterday's.
Thursday's list means it was there in the application bundle. Even then, I have uplisted, upgraded many applications. দেখুন তো কালকের লিস্টে 288 কি ছিল?
Milord, this is Mohammad Irfan.
Very well, I'll check up. Monday it will appear as to be mentioned. Let us see what can be done.
Very well. I'm so grateful.
জানাবাবু কালকের লিস্টে notice to your other side.
My Lord, may I mention one urgent motion, my Lord? It is, my Lord, on 10th, the district magistrate issued a letter and we received on 15th, and they, my Lord, execute the order on 21st, 25. And the proceeding is pending before the
Which
trial.
proceeding?
Proceeding is the Protection of Women from Domestic Violence Act.
Yes.
This proceeding is pending and the next date is 24th.
Yes.
In the meantime, they executed the order on 21st January 2025.
You are the husband.
I am the brother-in-law, my Lord.
Whatever. You file it in the department.
My Lord, kindly see, my Lord. On 21st, the date, your Lordship on taken on Monday. My Lord,
No, you file it in the department. Yes.
Thereafter, my Lord.
Urgent motion, my Lord.
But let it be listed, my Lord.
File it in the department. It will appear in usual course.
Well, I'm praying for leave to move an urgent motion, my Lord. It's a tender matter, my Lord. If the work order is being issued,
When will the tender be opened?
Opened and someone is still by giving the go by the prerequisites, my Lord.
All right.
I will satisfy your Lordship. Everything has been behind.
It has been opened.
Not yet. No, it's open, but the work order has not been issued, my Lord.
Work order has.
But after filing the, my Lord, RTI, so I got the information, got the paper on 10th of January and coming up before the Lordship. It's extreme urgent matter.
Which authority?
Is a government, is a Department of Women and Child Development and Social Welfare.
The government of India, Union of India, state government.
State government.
Very well. Let it appear on Tuesday. Serve notice. Tuesday as urgent motion.
Tuesday. Okay.
But my Lord, can say Monday, otherwise the infrastructure, my Lord. My DTT is absent. 21st will be effective.
Contempt application for
No inclusions. Yes.
contempt application.
Cannot be included now. More than 100 pages list. No place to include.
The matter is item number 161 of the today's list. It is a tender matter. Considering the urgency of the matter, your Lordship fixed the matter on 10th January. Matter is list since 10th January. There was a restraining order by the from your Lordship that not to open the bid. He has allow the petitioner to participate in the bid. We accepted the bid. Now we ask for seeking permission to open the bid. Otherwise, my Lord, it is relating to the security service of the.
Who is your other side?
I have served notice. Other side.
Serve notice.
Yes.
Which item?
Item number 161 of today's list.
You are for the respondent.
Respondent.
And the interim order was?
There is the petitioner will submit the bid. We shall not open without leave of the court.
So you want leave from the court
Leave
to
of the
open
court,
it.
Yes.
But then for that purpose, the matter is to be heard. Very well, as urgent motion it will appear. Give the number. On Tuesday it will appear. You serve notice by that time to the learned advocate who was appearing for the parties.
My lord, with
If you-
lordship's kind leave, I am mentioning contempt application, my lord. This matter was heard by your lordship, and since the appeal is pending, your lordship has directed me to mention it after the appeal is disposed of. On that issue, the appeal has been disposed of, and the order passed by not only by your lordship but other single bench. All the coordinate bench order has been affirmed by the division bench. Well, let it appear, my lord.
Please wait. I have refused mentioning of contempt application. When I take it next month, please mention. Yes.
May I have your lordships kindly for upgradation of item 109? This is a tender matter, my lord. The NIT was issued in the month of September 2024, my lord. Thereafter, I gave representation that this tender will only be given to such and such 3 persons. Ultimately, my lord, tender was not opened. Only in January, they opened the technical bid, and I found that those 3 persons are the only participant. Nobody else. I filed this writ petition, and after filing this writ petition, this week, my lord, they opened the financial bid and work order has been issued, my lord. Will be issued at any point of time. It's for shrimp seeds, my lord. Only 3 persons in West Bengal have been participated in the tender, and they have got
You
the
are
tender.
also one of the participants.
No, my lord, I could not participate because of the eligibility. Eligibility is such so that only 3 persons can participate all over West Bengal. And for the last 15 years, my lord, I am participating in the tender.
Very well. Tuesday it will appear as urgent motion. Give notice to your other side.
A similar tender matter in respect of West Bengal Power Development Corporation for production of sulfuric acid. But the persons who are not according to the NIT not eligible, those have been given the final the work order is going to be issued at any day. They have already issued the letter of award.
And you have participated in the tender process.
And I am L4, but I can show before your lordship the person who is L1, L2, they are not at all according to NIT is eligible.
Tuesday, urgent motion. Serve notice.
I pray for my lord's kind leave to move an unlisted motion. My lord, the urgency is that the excise license of the shop has been directed to be withdrawn with effect from 23rd of January. My lord, I am the licensee. I was a joint licensee. My other co-licensee died. I am running the shop. Now, just because his heirs are not coming forward, the license has been directed to be withdrawn.
And his heirs, are they against you?
No, no. There's no question. They will come of their own. They are not coming forward, and I have to suffer. My license will be withdrawn, has been directed to be withdrawn.
23rd.
23rd.
Very well, Tuesday. Urgent motion. Serve notice.
May I have you?
May I take my lordship mention, my lord, item number 1636 of the monthly list of your lordship's list, my lord. Here, what happened, my lord? I was the
Don't mention for upgradation.
of January, my lord, new contract has been issued to another contractor, wherein, my lord, and I was asked to take out all my lord, materials from the premises within a week.
File application, because these things arose after the writ petition was filed. So, file application, yes. No.
May I have your lordship's
Yes, please. What is the
May I
matter?
have your lordship's kind leave to move an unlisted motion? My license under the PNDT Act is an ultrasound clinic. I apply for renewal, 90 days over. I apply for renewal, nothing done, 90 days deemed renewal under the Act. Post that, they initiate a proceeding, and on 13th of January, I am communicated with an order saying that my license renewal has been rejected. No matter, they have no power to initiate the proceeding after 90 days. They initiate, they reject. A 20-year running establishment, diagnostic center, business has been closed down. But I was
Monday it will appear. Serve notice.
Yes, ma'am.
For non-prosecution, madam.
Give the number.
My lord, I wouldn't have bothered my lord for. My lord, this is a contempt application. I wouldn't have bothered your lordship for inclusion. The only difficulty that I am facing as on today is, my lord, the panchayat authorities, the officers working there have made my life a living hell just because this contempt application is being filed. That is the difficulty. Order passed in February 2024.
You want to withdraw the contempt or
No,
what? You want to
I
proceed?
do not want, unless this contempt is decided, my lord, unless this court protects me some way or the other, I am not being able to stay in my premises.
Very well. On the contempt day you mentioned. Call the list, please.
I appear for the state, my lord.
My lord, I appear for the petitioner, my lord. Here, interim order was passed, lordship. It expired on the 29th of December. My lord, the advocate on record, he was indisposed, my lord. He was unable to come to court, which is why for 7 days steps could not be taken. So there's been a corresponding delay. I'd mentioned the matter, lordship. Lordship advised that we should file an application. Instead, we filed an application.
Opposition filed.
May I file it, my lord? It's
And
ready, my lord.
Lordship,
That's
our
how
reply is also ready, lord.
The writ petition is not in the list today, so the opposition cannot be accepted.
on the next day.
Next day. And what about the interim order? This can
I
be
leave it to your
extended
lordship.
My lord,
because
leave it to
this
your
issue has to be decided. Otherwise, it cannot
So
be
I say, my
taken
lord,
up.
there is no threat or coercion, but they wanted a protection because there is no they are
understand.
document which shall not be registered. We shall not take it anyway. My lord, they have gotten.
And has the opposition been circulated?
So they have used a
it's
reply
been
also.
served. Our reply is also ready for filing, lordship.
Then this can be filed in the department also, isn't it? File it in the department.
My lord, we shall do so. We shall do
We
so.
shall.
Please come. The instant application has been filed seeking extension of interim order, which was passed by the court on 1st August 2024. Stop. Paragraph. Learned counsels representing the respective parties submits that the matter is ready for hearing. Stop. The affidavits have been exchanged. Stop. There is a point of law involved which is required to be decided by the court. Stop. Accordingly, let the interim order, which was imposed on 1st August 2024, be reimposed. And the same will remain valid till 30th of April 2025 or until further order, whichever is earlier. List the writ petition for hearing on 17th of February 2025.
My lord, may I pray, my lord, the monthly list of March, because my lord, this issue is my lord sub judice before the honorable division bench also. Two judgments were there, conflicting judgments, and
In
both.
that
my lord,
case, liberty to mention.
My lord, may I make this prayer, lordship? Kindly lists it on 17 February. If lordship, there's been no development in the meantime, my lord, we'll argue it out. My lord, kindly keep it on the 17th.
Since it is before the division bench, had it been before a coordinate bench, then it would have been okay. Then if it's because in the division bench.
My lord, that
when
is
will it be heard?
Those two
Likely
orders,
to be
conflicting
heard.
orders, my lord.
Likely to be heard? You're not sure. In that case, 4th of March. 4th
grateful,
March.
Grateful, lordship.
Much obliged.
Grateful.
GA is.
My lord, may I file the affidavit of service?
Yes, please.
It's already filed. Great. My lord, may I make one prayer? I'm submitting on instructions. I'm told that since the time has expired, because we had not filed it formally, we were waiting for it to be taken up. My lord, the department may not accept it. If lordship kindly,
The department is
for
directed.
both the parties, lordship.
The department is directed to accept the affidavit in opposition and the reply thereto to be filed by the parties.
Grateful, lordship. Much obliged.
Much obliged. I beg for the petitioner, my lord. The question is, my lord, we have a right under section 47A, my lord, to challenge the valuation given by the Inspector General of Registration as per the software. We have, in this case, my lord, we have paid the stamp duty because under the registration rules, unless we pay the stamp duty, we cannot deposit the deed. And 47A says after deposit, it shall go for adjudication. So this is the position. Our only prayer is that, my lord, we have paid the stamp duty, but it should go for the adjudication process because we are aggrieved by the valuation.
Yes, 47A.
Can I see the report once? The
Give a
valuation.
copy to the learned friend also.
Yes, madam. I will give a copy. Now, the valuation they are stating, Milord, upon the data, Milord, they filled up through online, through their Milord, computer and laptops. Now, on the basis of such, that valuation is come up, number one, Milord. Number two, Milord,
No, listen, if he is aggrieved, he has a statutory right under section 47A.
Subject to, Milord, he placed the document before the
Yes,
registration.
it has been placed for registration, Milord. It has been registered
Otherwise, how
also.
can he,
We shall again deposit the document. Registration has been done, but our grievance so far as not under 47A, that has not been taken care of.
Yes.
So it is the registered. We shall represent the document.
Now, Milord, once, Milord, the registration is also done, Milord,
Yes,
there, Milord, nothing remains, Milord, because they have already
then my right
registered
goes.
the document.
My right goes.
Milord, also, I have oral instruction that they might have registered the document in Alipur. Registration.
We have challenged. Yes, we have presented the document with stamp duty.
Now,
They have
section is not under
because
challenge, Milord.
no, I don't have to because I have paid.
It's
If
not
I
a question
challenge it,
of
Milord,
section.
then I shall not pay the stamp duty. In those cases, Milord, there was a challenge to this rule, so
Yes,
stamp
yes,
duty was not paid. But in this case, we have paid. I am not challenging the rule, but I want my right under the statute to prefer the appeal.
47A, you want to invoke that. Moreover, in the system, there has been unless and until the applicant brings any modification measure to data provided with the any consideration we may bring at the Do you have 47A?
My look, this 47.
Give once.
Listen, Milord. The document is to be presented if the registrar is not satisfied with the value.
After you admit the valuation and you pay the amount,
My lord.
Thereafter, whether you can.
No, I have not admitted. I have made my representation challenging the valuation, but then, Milord, it was presented. The challenge is prior to the presentation of the document. That is not annexed to the writ application.
This is what your learned friend is saying, that thereafter you have accepted the valuation and you have proceeded for registration also.
No, I have not. The writ petition was filed prior to Milord filing of the document.
Maybe, but
the
thereafter.
Writ also, my specific averment is that even if I present the document, that is subject to my right to appeal. I have made that prayer. Kindly see, Milord.
9th December 2024 is the representation prayer for reassessment.
They have to consider that. And I have to present the document again because they have to send that document also along with my prayer, my appeal.
So 9th December representation, you want consideration?
I want not as per prayer B and similar to consideration under section 47A. So it has to be not the representation as well as not the document. Both should go.
Document
also has to.
Otherwise, how can it be considered?
Otherwise, they cannot. Milord. I have to present the document.
Please take down once.
Kindly see paragraph 41. I have stated, Milord. Then I filed the. May I just place 41, Milord? Paragraph 41, page 14.
One thing is, which is taking the question, if they have admitted unpaid
No, there's no admission. I challenged it. Then, Milord, it was paid. Kindly come to paragraph 41, Milord, once.
Yes, they have
No, show me under which provision of law. 47.
My lord.
47A is the instrument.
47A, Milord, kindly comes to.
Kindly comes to. How to dealt with it. This is not undervalue. This is 47B.
Milord, 47 capital A, subsection 3, Milord.
No, this is where the instrument is undervalued. How it has to be dealt. Section 47A.
I'm just telling what is the procedure. Milord. I present the document with the set forth value.
Yes.
They accept it on the set forth value. Then, Milord, they ask me to pay that. This is the amount you have to pay. I do not agree. Then they send the document for adjudication. This is the procedure prior to, Milord, the new registration rules. This was old 47A. Then in registration rules, 124 is introduced, by which I have to pay the entire stamp duty upfront at the time of presentation of the document. So this rule takes away the entire right under 47A. This is the, Milord, conflict. 47A gives me a right. I can present with the set forth value, and the rule 124 says that you have to pay the stamp duty. Now, in the cases that I have filed before your lordship, there was a challenge to the rule saying that it is the statute is higher than the rule, so by rule you cannot take away the right. They have challenged, they have not paid, and the court has said you accept the presentation. But in this case, I'm not challenging the rule. I only say that my right under 47A cannot be taken away. So somewhat similar, only challenge to the rule is not there, because I
No, that is true. But here you have gone one step further. You have accepted whatever is the valuation that has
I have
been.
not accepted, but I have challenged the valuation. Then under the rule, I am unless I will not pay the amount, they will not take the document. This demand itself is not contrary to the statute. Kindly see the rule, may I just place rule 124 once. What they have done, 124.3. Your lordship is having registration rules. Kindly one.
Is it there in this book?
Second flag mark, yes, Milord.
Second flag mark, yes.
Rule 124, if your lordship kindly takes up, Milord.
124, presentation of documents.
3 is, Milord, upon satisfying himself that the provisions of sub-rule 1 and 2 are complied with and the stamp duty has been paid as indicated in the printout of the assessment slip under sub-rule 7 of rule 123, registering officer shall affix his signature on the document indicating the date and time of presentation. So I have to pay the entire stamp duty and present the document. This is the rule. This rule is under challenge because it takes away the statutory right. Court has directed, no, you accept the presentation and you send it for adjudication.
No,
now, in my case, what happened? Kindly text paragraph 41 of the writ petition, Milord. I made the representation challenging the valuation. It was kept pending because they say unless it is presented.
No, I understand, but then your right to appeal.
No, right to appeal is taken away. Kindly see that they say that unless the document is presented, you cannot. Kindly see the instruction in the last paragraph. The instruction that they have filed says with regard to referring any instrument under 47A, the instrument is required to be produced before the registering officer for registration, but not prior to that. So I have to present the document. One hand you are saying that for 47A you have to present the document, and 124 says you cannot present unless you pay the entire stamp duty. So they are compelling me by rules to pay the stamp duty. I have paid that by saying that if I pay, that is subject to the result of the writ application.
But then 47A is something where the conveyance is undervalued, and then your is not the case of undervaluation. Yours is a case where you are aggrieved by the valuation that has been assessed by the authority.
Assessment, by the assessment.
Right.
My lord.
So how will 47A apply?
47A, because, my lord, if your lordship sees, my lord, they are compelling me to pay this, whatever, my lord, is the computerized data, they are compelling me to pay on that value. I say the valuation is much less. It is 87 lakhs. But they are compelling me to pay
something more than that.
Yeah, more than that. The consideration in the deed is, my lord, 87 lakhs. If your lordship sees the deed, my lord, it is 87 lakhs. But they are compelling me to pay on 1 crore 54 lakhs. So that is the scope of undervaluation. The deed is 87 lakhs. My specific amount is there, but they are saying it is 1 crore 54 lakhs. Now, under the stamp act, the market value is the valuation, the highest value that the property can get in open market, if sold in open market. So that is my stand. That.
Please come.
One thing, Milord, may I say this? Can you visualize, he has agreed with the parties that subject to amount of X. Now, it can be anything. It can be below 87,000 also. It's 7 lakhs also. Now the question is, whatever amount they have fixed upon their personally, that cannot be determined what the registration authority thinks.
Give him an opportunity of hearing, because
provision is
47A5 mentions about an opportunity of hearing. According to you, according to your authority, the document that he has presented is undervalued.
Yes.
Right. And that is the reason you have assessed it at a more value, and he has paid the valuation, but his right to appeal cannot be taken away. It is only this minimum space or the place where the court is interfering. Please come. Is it a deed of sale?
Deed of sale that I have presented.
All right. A deed of sale was presented by the petitioners for registration. Stop. The registering authority found the document to be undervalued and directed the executant to, not the executant, the presentant of the deed to affix the valuation as assessed by the registering authority. Stop. Though the petitioner was dissatisfied with the valuation arrived at by the registering authority and intended to prefer an appeal, but was unable to do so because of the provision of Rule 125,
24(3).
124 within bracket 3 of the West Bengal Registration Rules, 1962, which requires the document to be placed before the authority for registration. Stop paragraph. The document in question has since been registered, but the petitioner is aggrieved by the valuation arrived at by the registering authority. A representation was filed by the petitioners before the Inspector General of Registration. Date?
9th of December 2024 at page 51.
9th is the date, but it was served through post. Acha, in December 2024. Stop. The same is yet to be considered. Paragraph. Learned advocate representing the state respondents relies upon the communication made by the additional registrar of assurances IV Roman 4 Kolkata dated 15th of January 2025, which mentions that for a document/instrument to be referred under section 47 caps A of the Indian Stamp Act, 1899, the instrument is required to be produced before the registering officer for registration, but not prior thereto. Stop. In the instant case, the subject document has already been registered. Stop. The petitioner will accordingly produce the registered document before the registering authority to avail the remedy under section 47 caps A of the Indian Stamp Act 1899. Stop. Paragraph. Has the authority been specified? The Inspector General of Registration or the registrar? Who is the author? The registering officer?
It shall be sent to the appropriate authorities. Normally, the Deputy Inspector General of Registration. It shall be sent, shall refer the matter to such authority in such manner as may be prescribed.
Yes, is the authority specified? Such
Authority
has
under
specified.
47A. That is not specified here.
Achha. The petitioner is directed to produce the subject document before the Inspector General of Registration, West Bengal, being the respondent number 2 herein, who shall take steps to invoke the provision of section 47 caps A of the Indian Stamp Act 1899 and consider the same strictly in accordance with law after giving a reasonable opportunity of hearing to the petitioners or their authorized representative at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. Paragraph. In the event there is any difference in the valuation pursuant to which this stamp duty has been paid, comma, then necessary consequential steps shall be taken by the said authority. The writ petition stands disposed of.
Extremely grateful, my lord.
Vicky. Take up the urgent matters. এই তারিখ থেকে 31 তারিখ।
My lord, I am for the petitioner. My lord, the petitioner before your lordship is an advocate, my lord, by profession, and he rendered his service under the panel of Central Administrative Tribunal, panel of Senior Counsel, Grade 1. My lord, point is very short, my lord. He rendered his service and submitted his bills. His bills were not squared off and were not paid on the alibi that there is some administrative difficulties, my lord, and there is paucity of fund. Kindly turn to, my lord, kindly turn to page number 25, Annexa P4. P4, I'm reading from C. It is, may not be out of place to mention that sudden cancellation of advocates panel made it difficult to this office to cope with the heavy load of work with insufficient manpower at this end to process the huge numbers of bills as well as nomination of advocates to all the returned pending cases and handling the new cases at the same time actually made it a Herculean task for the legal staff set up at this end. In addition to this, in addition to above, it is stated that most of the fee bills of advocates received by this end have already been forwarded to the department stroke division concerned for rearranging payment to the respective advocates. Moreover, it is well known fact that usually the railway faces difficulties in making payment of any kind of bill, including advocates one, in the last quarter of each financial year due to paucity of fund. That was given on 9th May 2023. Thereafter, several correspondences were exchanged. So, the petitioner made fervent request to the concerned authorities for payment of his bills, but despite the said situation, only a meager amount in the meantime, 1 lakh, about 1 lakh I have stated, was paid.
What is the due amount?
Due amount will be huge. About 37 lakhs as per my instruction. My lord, and lastly, my lord, only what is most paining that only they are referring about P11, last page 52. They are referring about only one bill. The advocate bill of Sri Ashish Kumar Guha for the subject case dated such and such for an amount of rupees 13,400 was sent to this office, a copy of which was forwarded to my client, Ashish Kumar Guha. This is internal correspondence in regard to only one bill. That raises doubt. Then they are only dealing with only one bill. There are so many numbers of bill I have mentioned in my demand justice and in my letter.
Page 11, you read out P11, page 52, the fourth paragraph.
Yes.
The request for revalidation was rejected. And for Ashish Guha, return reason was no address proof, no PAN. Are all these given? Resolve the problem was sent to
necessary action.
request submit self-attested copies of PAN and address proof.
There is no address book, no
After
pen.
getting the required documents, the same was
To resolve the
uploaded in the
problem, a
export
data
to validate
was
and
10th
process
July.
All
That I
right.
can submit.
1 minute. The physical copies of the
That I can submit always. I received
Oh,
payment.
wait,
I have
wait.
this.
The sent to CAO, but the bills more than 2 years are not allowed to pass.
Regulation 44 physical copies of the advocate's bill were sent to they are saying that physical copies were sent.
Was contacted
But the accounts authority returned the bill through
which was received by
IMS portal with return remarks. Bills more than 2 years old are not allowed to pass. They have kept it pending. Passing of this bill requires approval of PFA.
Then very unfortunate thing.
Very unfortunate.
If there is any dues, the authority is bound to pay.
Yes.
Only one thing, just now I have got the one instruction that in reply to the letter dated page 41.
41.
Learned advocate of the petitioners.
The
railway has sent a letter to the learned advocate Ganguly that stating that he has submitted the total 170 numbers of bill. Out of that, 155 has been processed. And the railway also requested him to submit the details which bill has not yet been paid to fill that day for taking further steps. Anyhow,
but they have not shared with it.
The railway is bound to pay.
They have not shared with any.
When will the payment be made? This is the only query of the court.
And that later, just now,
It will not be of any use because 52 is thereafter. See, it is October 2024. It mentions that bills for.
But this is I'm submitting that if there is any dues, authority are bound to pay.
Yes. When will the payment be made? You take instructions, file a report, whatever. What can be done?
I think instead of report, kindly direct them to pay. If whatever may be the dues, or
I will not dispose of the matter.
Grateful.
I want to see that the payment is made, I'll dispose it off. So when do I keep it? Please come. A legal practitioner.
Can I submit one thing, kindly direct the petitioner also to submit the details for the non-paid bills.
I think I will not pass any direction. They will again take up new issues. All documents are with them. A legal practitioner who rendered service to the railways. Who rendered professional service to the railways has not received his financial dues. Stop paragraph. Learned advocate representing the respondent authority is directed to revert with necessary instruction specifying the date within which the dues of the petitioner will be cleared. Stop. The matter is adjourned till 31st of January 2025. 2 weeks time.
Grateful,
Letter report.
Evidence services.
Letter report.
That may be kept on.
Indicating the date of payment be filed before this court on the adjourned date.
Great. Deeply obliged.
Service is taken on record.
My lord, 4 I appear for the petitioner.
Before my license starts, this matter relates to public premises eviction of unauthorized document. In my way, we should go to Google Honorable Justice Joyce.
No, cannot. No, my lord, it is an enemy property. Wherefrom, my lord, I have been, my lord, I have been declared as an illegal occupant.
1 minute, let me check up the
Yes.
determination.
The Public Premises Eviction of Unauthorized Occupant Act. Determination is tagged with Justice Joseph.
Yes.
And he is challenging.
West Bengal public land eviction, but does it fall?
No, no,
Oh, no, Public Premises Unauthorized Occupants Act 1971.
My lord, prior to that,
Public Premises Eviction of Unauthorized Occupant Act as well as West Bengal Eviction.
Yes, yes, yes.
my lord, prior to that, kindly come to page 55. My lord, I have been declared as an illegal or unauthorized occupant under the Enemy Property Act. My lord, kindly comes to page 55.
Proceeding had been initiated under the Public Premises.
That is after that, post that.
He is challenging an order for eviction.
Page.
Page 58. The order is 19th of September 2024.
19 September.
Yes, Public Premises Eviction of Unauthorized Act. Please come. The matter relates to the public premises, bracket open, eviction of unauthorized occupants, bracket close. Act, 1971. Stop. This bench does not have determination to take up the matter. Stop. Let the same be released from the list
My lord,
of
only
these
one
bench
thing, my lord, may I pray?
and be placed before the bench having determination.
My lord, only one thing may I pray, your lordship. My lord, the notice was issued to me on 7th of January, granting me 10 days of time, my lord. Otherwise, they will use force and my lord will...
What will I do?
My lord, till that time, my lord...
Does
my
this
lord,
bench have determination? What do you want?
my lord, I will... My lord, 10 days will expire, my lord, today.
You ought to have taken steps to see which bench has determination. Go and file before some other bench. Revision, second appeal. Go file anywhere. Call the next matter, please.
Lordship, in this matter, I am appearing for the petitioner, Lordship.
My lord, in this matter, I am appearing for the respondent number 2, Ombudsman. My junior should be present in court. On the last occasion, I had indicated that the complaints received from the petitioner have been closed. So your lordship wanted me to file by way of an affidavit to disclose 2 of the correspondence by which such complaints were closed. In view of that, my lord, by taking that into account, the writ petition may be disposed of. I have disclosed it in my affidavit. Mr. Raja Roy Chaudhary should be there to hand it over to your lordship's court officer. I have also served a copy of this on the petitioner, my lord. If your lordship kindly looks into my affidavit, which I have taken out, paragraph 8, Roman 4 and 5, read with pages 11 and 13.
But I have not received any copy, my lord. I am Union Bank of India, respondent number 1, 3, and 4.
Yes,
But
yes,
I
Union
cannot know where the
Bank of India is not served. I'm told
Yes,
by my advocate on record.
Petitioner, are you aware?
Yes, I am aware of this, Lordship.
Yes.
They have served me yesterday.
What will be your submission?
Lordship, my submission will be that, Lordship, bank respondent number 1 was required to execute a fresh lease agreement with the prevailing market rate, Lordship. That's it. Nothing more than that.
My lord,
We-
that's a purely contractual dispute which can't be gone into in this writ petition, my lord. The very purpose of filing the writ petition was that the complaints which were lodged with the ombudsman were not considered, but those have been considered and those have been already closed and communicated well in advance prior to filing of the writ petition even. So those were suppressed and the writ petition was moved. Those may be taken into account and then the writ petition may be disposed of in view of my affidavit, my lord.
Lord, it is a landlord tenancy because I am the tenant and landlord is the writ petitioner. Lord, the property loan was taken initially by a person whose account became NPA, and the property was sold in wherein I was a tenant. And the property was sold, and the petitioner, the writ petitioner, they purchased the property from the bank in the SARFAESI proceedings. Then, they have stated that let the agreement, fresh agreement is required to be entered into. Then I have sent that previously an agreement was entered into in between the previous owner, 15 years, and the terms and conditions were set up therein. Kindly see that agreement, and if you are agreeable with regard to the terms, then okay, we will execute the lease deed, fresh lease deed. Then, my lord, they have said, yes, we are agreed. Subsequent thereto, they have changed their mind. And now they
Lordship,
are
that
saying
time they
they are
have
not in agreement.
urged
So
to
this is a
see that
purely, this is not a public functions. This is a private agreement entered into in between. So my first question was with regard to the maintainability of the writ petition, because a dispute in between the landlord and tenant.
Lordship, first of all, we agreed to the terms, but we overlooked that the rate they were imposing that was not prevailing to the market rate, Lordship. Therefore, we asked them to increase the rent so that we can execute the fresh lease agreement. But they never intend to do so, Lordship. They never respond to that, Lordship.
With deepest of respect, my lord, may I just interject here?
No,
This
please
is
do not interject. I am yet to understand what the writ petition is about. I am keeping your affidavit on record. Let the parties come and make submissions. I just cannot understand what the writ petition is about. Please come.
my lord, the writ petition is squarely about the
Let the
rent not being increased.
let the petitioner place her case,
Very
and
well,
let not
very
the
well.
respondent place the case of the petitioner.
Very well.
Lordship, this writ petition has been filed that the respondent number 1 was the tenant to the writ petitioner. When the writ petitioner purchased the property, in the respondent number 1 assured that they will execute a fresh lease agreement with the prevailing market rate of that property. Thereafter, after taking possession, after registered the deed in the name of the petitioner addressed to the respondent, intimating them that now we are the current owner of this property and you are required to execute a fresh lease agreement with the prevailing market rate. And thereafter they have come up with their agreement, which was executed earlier, and after going through the documents we find all the terms and conditions were correct, but at that point of time petitioner overlooked that the rate which they have fixed was not prevailing to the current market rate. Therefore, initially we agreed to proceed with that rent agreement, but thereafter we again wrote to them that kindly make the rent amount in the with the current market price so that we can proceed with the registration process. But thereafter they never came up with the fresh with the prevailing market rate, and we continuously intimated them, communicating with them to execute the rent agreement with the prevailing market rate, but they never agreed to that. Neither they intend to execute a fresh lease agreement. Therefore, we have filed this writ petition so that the respondent number 1 can execute a fresh lease agreement with the prevailing market rate. Lordship.
Affidavit in opposition filed on behalf of the Ombudsman, Reserve Bank of India is taken on record. Stop. The petitioner happens to be the landlord of the respondent number 1. Stop. The petitioner intends to enter into a deed of a tenancy agreement with the respondent number 1 at the prevailing market rate. Stop. The respondent number 1 is not willing to do so. Stop. The petitioner has approached this court for relief. Stop. Paragraph. The court is of the opinion that it is between the landlord and the tenant to settle the terms and conditions of the tenancy agreement. Stop. The writ court is not the competent authority to decide any issue between a private party and the bank. Stop. The bank in the instant case is not providing any public service for which the writ court, for which the jurisdiction of the writ court can be invoked. Stop. In view of the above, the court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed.
Grateful to Lordship.
Oblige, Your Lordship.
Item number 1, Your Lordship, I am not pressing this application.
Why?
My lord, the statutory appeal has been preferred before the learned court below.
Learned court below, all right. Learned advocate for the petitioner submits that a statutory appeal has been preferred by the petitioner before the competent forum. Stop. The petitioner is not inclined to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed.
My lord, there is a contempt application in connection with the same, my lord.
The contempt application stands disposed of. Who is the advocate on record?
My lord, I'm not the advocate on record, my lord. I'm his junior in this.
So the advocate on record has instructed you?
Yes, my lord. Yes, my lord.
Yes, too.
My lord, petitioner wants to withdraw this application.
Why?
My lord, communication letter is handed over.
এতদিনে একটা ইয়ে করা গেল না, কি করে সেট করতে হয় সেটা করা গেল না, প্রবলেম করছে। Review, not press. Communication is there.
Gratefully, Your Lordship.
Yes, 3.
Please, Your Lordship, for non-prosecution for the petitioner.
Why?
Section 14 application was filed for passing order after filing the order has been passed by the learned DM it has become
All
infracted.
right.
Written
Learned
communication from the
advocate
back.
for the petitioner submits that the grievance of the petitioners has already been redressed by the authority. Stop. Next. In view of the above, the petitioners do not intend to proceed with the writ petition any further. Stop. The writ petition accordingly stands dismissed as not pressed.
Much obliged.
Three.
Item number 4. Your voice is breaking. Whoever is there online, the court cannot hear you. The court cannot hear you.
My lord, in this matter, Sri Mukherjee is for the respondent, my lord. He is ill, my lord. He has not come today, my lord.
Which
Kindly not today.
Which respondent?
My lord, I am informed this.
Physically,
Madam, the court cannot hear you. Your sound is breaking. Your connection is very unstable.
My lord, respondent number 3, my lord. Sri Mukherjee. He is ill, my lord. He has.
Who is he?
20 तारीखे physically.
My lord, Sri Mukherjee.
Who is she appearing for?
Respondent number 3.
Who is the respondent number 3?
Jiblal Jha. Jiblal Jha. Jiblal 3. Respondent number 3.
This is item number 4 going on.
4, my lord. Item number 4, my lord.
Item number 4. Yes.
Respondent number 3, my lord.
Madam, can you make
Yes, ma'am.
submission?
ম্যাম আমি নোটিশ সার্ভ করেছি সবাইকে, আমি ডকুমেন্ট নিয়ে 20 তারিখে ফিজিক্যালি অ্যাপিয়ার করব ম্যাম, আপনি 20 তারিখে ডেট দিয়েছিলেন।
Very well. Let the matter appear in the list on 20th.
থ্যাংক ইউ ম্যাম।
The petitioner appears in person virtually. লিখে নেবেন।
Look, I'm preparing for the petitions.
Evidence service.
Lord, I have sub. Lord, I have sub.
Yes.
Lord, the
Bar
fact-
council.
Yes, madam, there is no grievances at all before, but
No
towards the
grievance
bar
with the
council.
bar council.
No, but this
Your
is
grievance is against?
the bar association. But as because your lordship asked me as to how the jurisdictions amenable in respect of that. Actually, my lord, I am relying on decision rendered by Karnataka High Court. Yes, Bar Council of West Bengal is a party therein because
To be so, my lord.
yes, I have served. I have served.
Collect a copy from your client. He has already served.
I have served, my lord.
And
Here, my lord.
petitioner-
Here I have served.
Yes, yes. Petitioner is
And
the
sir-
learned advocate, so you cannot expect more than one copies to be served. Collect it from your client. Yes. What has happened?
What happening is this, my lord, the petitioner enrolled with the State Bar Council. My lord, in 2024.
Hmm.
Your lordship will find that-
2024.
Yes,
Absolutely young advocate.
my lord, my lord.
What has he done? Bar association will go against him.
Yes, my lord, this is very, my lord, these peculiar circumstances. After enrollment, but your lordship is aware, the granting of enrollment by the State Bar has to follow the procedures laid down in the State Advocates Act. My lord, after verifying all the documents, they give the enrollment. My lord, your lordship kindly see page 46 is the letter of enrollment. Now, my lord, he is practicing at my lord, the Chanchol and my lord, the Chanchol district subordinate court of Chanchol. Now, my lord, the Bar Association of the Chanchol Bar Associations, my lord, ask some document to be placed before the Bar Association for verifications or something else, my lord. Thereafter, they found one of the last annexures, they found that there is some discrepancies with regard to the documents which he, after my lord, getting the my lord, membership of that bar associations, because the initially he made
What
the
is the document which the bar association is wanting?
Yes, my lord. That is not, my lord, clearly, my lord, this, your lordship is the last notice. That is, my lord, the annexure P8, page 56. And my lord, nothing has been given, my lord, here the grounds. But the whole issue, my lord, relates to, my lord, he is not even entering in the premises of the court. He is not, my lord, he is obstructed to, my lord, move before the court. And, my lord, even outside this, my lord, this is very difficult. My lord, these
54 members have been debarred.
Yes, my lord, I am for the only one. But this
I
petition-
understand, but page 57 contains
my
a
lord,
list
this
of
your lordship,
54
yes.
members.
Yes. The reasons I don't know, but because this is not there, madam. And my lord, there no reasons.
Let
and
me see
more-
the Karnataka High Court judgment that you are relying.
I'm sorry, my lord, Kerala High Court judgment.
Very well, Kerala.
But
This
the-
is, let me see.
1992 SCC online, my lord, Kerala 207s. My lord, this is my lord, correspondence to my lord, AIR 1993. My lord, I am placing this. And more so, my lord, these two acts, my lord, which relates to, my lord, the one is the Advocates Act, section 6 of the Advocates Act. And, my lord, the other, my lord, the acts which, my lord, State Act, which, my lord, this West Bengal Advocates Welfare Funds Acts 1991. Well, that is very peculiar, matter. Unless I be a member of a bar association, I cannot get the benefit which intend to be given to me by the State Bar Council under this act. West Bengal Advocates Welfare Funds Act.
Suppose an advocate is not the member of the bar
Well,
association.
that this act says. This act, section
22A.
Section 22 of the Act. My lord, may I please, my lord, this is very, my lord, for that reasons also,
There are many advocates practicing over here who are not the member of the High Court Bar Association.
That true, but
Does
this
it
act
mean
says
that
your
they
lordship,
cannot
I am not
practice?
That true, your lordship. Well, your lordship can see the act itself. Well, I am giving. Well, section 22.
This is the Welfare Fund Act.
Yes, well, this act says if I intend to get the benefit of that benefit of the welfare benefits, then I have to be a member of any bar associations. But this is 22. Well, your lordship kindly see section 22. Well, this is a statute. Well, this is a statute which says so. Now, well, the other thing is this, well, section 6 of the Advocates Act, what says, well, the power which has been empowered this State Bar Council to protect the right and interest of a practicing advocate. So that has to be done by the State Bar Council. They would have asked this to the Bar Association as to what are the reasons on which he is debarring from entering even the premises of the court. And these bar associations within the premises of the Chanchol court. So they are even
Listen,
not allowing
the page 56 says that the following advocates are not going to avail any facilities from the Bar Association. They have not debarred the advocate
Yes,
from
yes,
practice.
they debarred, they debarred. I'm giving, I'm giving. Your lordship. Prior to that, page 57, your lordship can see. And your lordship will find the list of disbarred advocates.
Debarred advocates from using the facility of the Bar Association, not the facility of
I
practice.
could have understand. The facts remains that the person, the petitioner, also restricted in entering in the premises of the court. That is true. If it is not, I would not have to come before my lord saying that this is also Article 21 is violating by this and this is amenable. But I only ask on interim stage that the Bar Council, State Bar Council, Bar Association should be directed to states.
Show from
And
this.
Let the petitioner be allowed to even get entry of the premises to the not only the petitioner itself, the clients are also involved in these matters because the matters which are already filed on behalf of the clients by the petitioner, they are also suffering for this. Even I have heard the petitioner is here, I have heard that the petitioners and some others advocates, those who are trying to see it even outside the premises of they have been they are from there, they are trying to dispose these bar association members. And the court, the robes that has been I have heard the petitioner is here, the robe, but that has been turned down, that has been torn. But this is going on how? The petitioner only I am for this particular petitioner. Your lordship can
No, today only one petitioner is there. Tomorrow,
I am only that.
54 candidates
that
they
may have come.
They may come. They can come. Right. So
I am for these petitioners. This has to be stop. These atrocities has to be stopped. Only. And the recognition of the Bar Association has to be given by the Bar Council. That is under the Welfare Act, your lordship kindly see. So the Bar Council is also responsible to the acts or the actions of
1 minute.
Bar
1 minute.
Association.
You appear for the Bar Council of West Bengal, right? Today you do not have the brief. You take a brief from your client and take down a note, page 56 of the writ petition. This is the Bar Association's resolution, right? It mentions that the Bar Association, page 56, the Bar Association found that the educational certificates, admit cards, mark sheet, registration certificate, there are discrepancies. Where from does the Bar Association get the power to look into all these things? Once the Bar Council grants an enrollment, that is enough for the Bar Association to use it. the Bar Association does not have separate powers to verify these documents. Just go through these and come back. I'll keep it on Tuesday. Today is Friday. You get one more working day in between. Have you followed?
Because I have to take instruction.
Take instruction. The learned advocate is not being able to practice. So this is extremely urgent. His clients are there. He cannot enter. He says that his robe has been torn. This cannot be the way how the Bar Association can function. You get it? So I'll give you at least today it's not even 12. You intimate your client. Monday you have the whole day. Tuesday you come back.
My lord, Wednesday kindly fix it.
Please. But I am still not gone through this decision as to whether it will be entertainable or not. But
that's why
then
your lordship is consider this decision.
I will look into it.
I only get these decisions which are rendered by the Kerala High
I will look into it.
My lord.
There is some matters against this High Court Bar Association also. See whether writ petition was filed or not.
But that our High Court held that the writ petition cannot be maintainable in
Yes.
that I have gone through. But here also, this difference is this. When the bar associations, I have why?
Very well. Don't make your submission today. Reserve your submission, and I am reserving my opinion. I want to see how it can be resolved.
The affidavit of service be kept on record. I have
Has charge will been served?
Yes, that bar associations also be served.
The petitioner is a practicing advocate of the district of Malda. Stop. He.
May I only one thing, may I get the interim order, so that he can be entered into the court premises to that effect. I am not whether he entered into the bar association or not.
All right. The petitioner. Yes, he was a member of the Chachol Bar Association. Stop. By a resolution dated 16th of December 2024, the Chachol Bar Association has debarred the petitioner. Where is your name in this page 57?
On the page 57, serial number
Oh, 313.
37.
That is it.
In serial number 36.
Yes, I got it.
41.
Debarred the petitioner.
47,
page 57.
From availing any facilities from the Bar Association on and from 17th of December 2024. Stop. The notice published by the Chachol Bar Association mentions that the Executive Committee of the Bar Association unanimously decided in an executive meeting an adopted resolution to debar certain members from the Bar Association as various discrepancies were found in the documents like educational certificates, admit cards, mark sheets, registration certificate, etc. of the said members. Stop. The said members stop by which the members obtained enrollment number from the Bar Council of West Bengal. Stop. It has been submitted by the learned advocate representing the petitioner that the petitioner has been prevented to enter into the court premises, his robes have been torn, and he is also not permitted to appear in the court to defend his clients. Stop. Next. allegation is that the Bar Association is infringing in the petitioner's right to profession, and his right to life is also at stake. Right to life and living. Stop. Next. The Bar Association is not represented today. Stop. An affidavit of service is on record. Is not represented today. The affidavit of service does not indicate as to whether there is no proof of service of the writ petition upon the Bar Association. Stop. Next. The on a perusal of the impugned resolution of the Bar Association, the court is left wondering as to the authority of the Bar Association to verify the educational certificates, admit cards, mark sheets, and the registration certificate of a member who obtained enrollment from the Bar Council. Stop. Paragraph. The Bar Association cannot stand in the way of the right to practice of any advocate who has obtained enrollment from the Bar Council under the Advocates Act. Stop. Next. The learned advocate representing the Bar Council of West Bengal is directed to revert with instructions. Paragraph. List the matter on 22nd January 2025. Stop. The HON'BLE Bar Association and its office bearers are restrained from interfering with the practice of the petitioner as advocate till 31st January 2025 or until further order, whichever is earlier. Stop. The Bar Association shall permit the petitioner to take back his articles. You want to take your articles back from
that
the...
has not. No, my lord, that has not yet been. They have kept it.
You want to take it back, or you want to keep it over there?
Want to take it back. My lord, take it back, my lord.
Will permit the petitioner to take back his personal belongings, which are kept in the premises of the Bar Association peacefully. Stop. Let a further notice be issued on the non-appearing respondents communicating this order. Stop. Come back on the next day.
And only one indulgence, my lord, is page 57, but his serial number is 37. My lord, I think, but it's not record because your receipt is
37, I see 37.
And my lord, I have already handed over an extra copy of the writ petition.
For the respondents, I'm for the state in this matter.
Executive service.
The petitioners, with like previous years also, they applied for this year International Book Fair for a stall. They applied according to their terms and conditions with all documents, as they used to do in the earlier years. Till date, they have not been informed that the stall is going to be allotted. They have come to know, I do not have any basis of that, whether any lottery is held or not, and that lottery is being probably held and is being allotted. But till date, they have not. So at this stage, they have come up. I have to, for allotment of stall.
But in the earlier matter, probably the lottery was held, isn't it? On that day itself, the lottery was supposed to be held.
It was for 100 square feet, my lord. It is for 600 square feet, ma'am.
Is
This
the
is also
square feet very important, or is the participation important?
It was done on different days. For 100 square feet, it was done on a
All
separate
right,
day,
all right,
and
all
for
right.
600 on a separate day.
All right, all right.
So, they have applied.
So the lottery has taken place.
Now I have
Everything is complete.
Everything is complete.
Yes.
So I have to show you lordships that I have
The writ petition
applied.
is maintainable.
I have maintainable and I have applied in accordance to the terms all that. If your lordships, may I go to the maintainability point first?
And the you are entitled according to their advertisement to.
Exactly. Now your lordships kindly see the page 53, their advertisement.
Yes.
Now, first part also very important, but I will come to the, when I will deal with the second aspect of the matter, then I will address on that. Kindly see the advertisement. Publishers and Booksellers Guild organizes.
Page 53.
Page 53.
No, it's something else. It is your document. We show in the Porishad.
Pagination আবার এরকম হবে নাকি তো সৌরজিৎ? Page 50.
No, 53, 54, 55 are all your documents. What is there at page 53 in your brief? 53. Mine is 52. This photograph.
Oh, that's one page.
Oh, which page are you referring to? The photograph?
Photograph.
All right, this is 52 in my
Bottom
page.
portion.
Bottom portion, yes.
Bottom portion your losses will find. Publishers and Booksellers Guild organizes 48th International Book Fair from 28th January to 9th February. Interested participants may apply in their letterhead with name and address, number 1, 2 space tall square meter or table space, 3 space allotted in 2024 fair, 4 Xerox copy of necessary license, registration certificate and catalog, 5 latest magazines or newspapers, and 6 undertaking to abide by the rules and regulations of the fair. These are what they have published, your lordships. Now, your lordships, kindly come to page, very next page, I believe, should be your lordships. Now I am little bit 54 according to me, your lordship, 53. Your lordships will find this is a request. This was on 22nd October 2024. We would like to invite your kind attention to the fact that we are being allotted with a bookstall in the Kolkata Book Fair in the last several years by your esteemed organization. We request you to allot us with 600 square foot bookstall at the upcoming Kolkata International Book Fair of 2025. Then your losses, next page, undertaking. We do hereby declare that we will abide by all the rules and regulations of the 48th International Book Fair as put into effect by the organizations, that is Publishers and Booksellers Guild or any other competent authorities. In the bottom, your lordships will find name and address, space tall, space allotted in 2024 fair, Xerox copy of registration certificate and latest magazine. Now I take your lordships to the registration certificate. That's your lordships will be getting at page first, my lord, as a society registration, your losses will be getting at page 20. I think, my lord, probably your losses page would be 19.
Let me see. No, page 20. Certificate of registration.
That's okay, my lord. This certificate of registration is a society registration act.
Hmm.
My lord, page 22, all your lordships will find. So for exemption certificate under the Income Tax Act or registration, my lord, regular income tax pay. That's probably not so very, my lord, important over here. Page 21, 22. Now your lordships will find the next page 24. That's the certificate of registration under the Press and Registration of Books Act. That's publishers registration as a publishers. My lord, we publish the books and also, my lord, we sell the books of different Prokashonies, my lord, publishers. That we have, my lord, the catalog we had given to them. These are the documents we supplied. Then your lordships will find we made a representation when this is, my lord, we came to know at page 56. I don't know, my lord, your lordship's page would be, it's page 55 or not. That please do it on 10th January 2025. I think
Yes, 10 January
2025.
folded page.
Folded page.
Hmm.
But that's, my lord, email communication. I don't
Email
know, my lord.
communication.
But before that, your lordships will find the hard copy of this. So we made representations to them. Please do something. We are waiting for that. I tell you, lordship, the modus operandi. This is not a format application. It's an application in form of request. Please give me. Then they call for us. We give certain amount deposited for the square meter foot wise. Then, my lord, they give us a form to fill in with details. And we have to secure, my lord, the file license, all that like previous years. But before that, unless I deposit the money according to their instructions, I can't get all this. So that stage I couldn't reach because they didn't inform us. Every year they inform us. Please come. This is that today is the date of lottery, all that you appear. That's why before that we made a representation of 10th January. Please inform us when we are going to hold it. This is your lordships will find. Kindly see, my lord, let us press it, your lordships. I skip over the very first
Then
paragraph.
what happened?
Then, my lord, we have, my lord, come up before your lordships. We have not been informed like anything. No reply to this. Nothing was informed. Even, my lord, one day, my lord, they told us tomorrow phone us in a particular number. Your lordship, we have given me the probably number also. Someone, yes, your lordship, in the page 56, the fourth paragraph, the number we have given. On the Saturday, last Saturday, my lord, my Friday told us to make a ring on Saturday. But on the Saturday, nobody picked it up. Then we made them. They said, we are looking into it. This is the way, my lord, they wanted to delay it so that they can come up before your lordship and say, this is over.
Yes.
The regular participant, my lord, I know your lordship, the regular participants is not so very factor unless they fulfill the criteria. But this is the fact, your lordship, I'm doing that. So you know me, this organization.
Last occasion, the petitioner who approached was neither a publisher nor bookseller, nothing.
This time also.
They are not so.
No.
They have given
lord,
their registration number.
Page 24 that my learned senior friend has
24.
pointed out. My lord, that is Vishwa Hindu Bharta. That is the publication of House of Vishwa Hindu Parishad. But this document, page 24, was never a part of the original application. That is my first point, my lord. The Vishwa Hindu Bharta is a publication house. But, my lord, the petitioner before your lordship and the applicant before the guild was Vishwa Hindu Parishad, who is neither a bookseller nor a publisher.
Now, this the petitioner
Yes, madam.
Publishes this Vishwa Hindu Bharta.
It has a separate registration number. My learned senior friend has shown you.
Yes.
So application has to be through the publisher. It has not been the number one. Number two, my lord, my learned senior friend has pointed out page 55. My lord, kindly consider serial number 4. There is a specification that catalog of the publications have to be given. Nothing of that sort was annexed to the application.
You could have sought for. They are here for so many years. You could have sought for that these are the shortcomings. Please provide all these things.
But the application itself was incomplete, my lord.
Well, why did you not intimate them?
These shortcomings were there, my lord.
You should have intimated them. You could have intimated them, or you deliberately don't do it.
It was rejected at the very threshold, my lord, because it did not meet the essential criteria.
The rejection was made in October. When was it made?
After 30th October.
After 30th of October. 30th October was the last date.
Yes, madam.
Right. And even in January, they go on pressing you for consideration of their application. You do not find.
10th January, my lord, that they had written.
All right.
Only
So from October till November, December, you didn't find time
They
to
never
intimate them.
contacted us, my lord. In the interregnum period, they never contacted us. It is only for the first time that on 10th January, my lord, that they, after the order was made in the
Earlier
Act matter, my
petition.
lord, yes, my lord, that they had given this application to us on 10th January itself. My lord, for the interregnum period from 30th October until 9th January, my lord, they were in their slumbers, my lord. My lord, and the guild has rejected their application at the very threshold because, my lord, it did not meet two essential criteria. Number one, my lord, the application was made not by the
Are you aware that they have their publication house? Vishwa Hindu Parishad, relying upon page 24 as their publication house, and they have books or the catalog. It has been submitted. That catalog
No,
was
my lord,
submitted.
that's not catalog, my lord. My lord, kindly. Latest magazines have been submitted. Page 50. Only one magazine has been submitted. Kindly have a look at page 55.
Is there any specification as to how many magazines or how many publications?
Catalogs, man.
Catalog means
All the books, my lord, which they want to my lord, exhibit in the book fair, my lord, that has to be there. And we have to also scrutinize, my lord, as to whether, my lord, about the my lord, catalog is asked for, my lord, so that we can conduct the scrutiny as to what should be there and what should not be there, my lord.
She could have informed me.
What do you mean by what should be there? It is their book, and they will publish it according to their wish. They write something and they publish it.
There can
Whoever.
be some sensitive books relating to certain sensitive issues may be there, mother. We do not want to go into all those.
Did you intimate that these are the sensitive books and these are the insensitive books?
They should give us the catalog, my lord. Unless they give us
Call
the
for
catalog.
that. My lord, I have given all.
That,
My lord, these are my public books.
Do you have?
Yeah, these are the public books. I have the catalogs
How many?
also.
Where is the catalog?
I've given you, Lordship.
No,
Everything.
don't give it to me. It is for them to see.
We
quote
have
is
given
some-
the catalog also.
Where? Show me that you have given the catalog.
My lord, I tell your lordships, kindly see the advertisement. Xerox copy of necessary license or registration certificate and catalog, and then latest magazine and newspaper. My lord, your lordships will find over here your lordship Xerox copy of registration certificate and latest magazine. My learned friend is saying that this is not publishers. Your lordships, kindly have a look at this book.
No, show it to the authority.
This is the book.
The book they have published.
Have a look at the pleadings at para 5, my lord. They say that they have 800 books.
They have
800 books. Kindly have a look at the pleading at
Is it impossible? They cannot have.
No, my lord, not on that, my lord. Unless they say as to what they're going to display in the book fair, my lord, we cannot act upon.
You have an advertisement in place.
Yes, my lord.
And they say they have acted in accordance with the advertisement. The
Catalog
court
was
is
not furnished, my lord.
So you call for that.
They
You
never
rejected that.
approached us. Since
Oh,
there was no
my lord,
catalog,
kindly have a look
the
at page
application
10.
was rejected at the very threshold.
This is more so the reason you should have intimated them, because
No,
they say
rejection was intimated to
they
us.
were participants for the last several years.
Yeah, 2011.
Well, they met the criteria, my lord. That is the reason why they were permitted.
Then you have the catalog of mine.
Till last year, you permitted them to
yes, ma'am.
they were there. You must be having all documents of these authorities.
Rules have changed, Mala. This year, Mala, kindly have a look at rule number 20.
These rules are not statutory rules. Don't show statute.
But
Right. These are your own rules.
These are part of the form itself.
These are all made on your own.
Mala, yes, ma'am.
No statutory effect at all.
No.
Right? You have permitted these people to be there for last so many years. All on a sudden, you just wake up and say that no, you don't have a catalog. What were they doing for the last so many years in the book fair? Why did you permit them?
Mala, this year, Mala.
Why did you permit them for the last year? They were sensitive.
No, Mala.
Insensitive. And suddenly the sensitivity arose, increased.
This time there has been change of the policy, Mala.
Mala, policy is not published.
They were aware, Mala. These
Published
rules were part of the form.
Which form?
itself.
Which form? Kindly don't
Listen,
say that.
You are not a statutory authority.
No.
There must be a limit, and there must be at least some manner of decency in which you will function. If you function in such a manner that everything becomes so very naked, then it becomes difficult to accept it.
Mala,
right?
This year, Mala.
You permitted these people to stay over there for last so many years. All on a sudden, there is a change of policy, there is change of this new forum. What is
They were
this?
aware of the rules of the
Why did
game.
you not intimate them?
How do you make us aware?
This was their part of the application form.
Application form is given after the money is deposited. Sorry.
This is part of the rules, Malad.
Which rules?
Which rule?
Malad, they had the application form, Malad. In the application form, this
Where is
was
the application form?
টাকা জমা দেওয়ার পর দেন।
Where is the application form? Is this form available to everybody?
Malad, time grants me awareness.
Malad, I have given previous year documents also, one after another. Malad, kindly have a look at page 50 and 51, previous year. First, I deposited the sum, then they give me the document. Then they give me the document. First, deposited the sum, 21,000.
Part of page 44, Malad. Kindly have a look at page 44. Malad, only the front portion of the form has been annexed. Malad, at the back side of the form, Malad, rules are specified.
This is previous year.
44.
This is given your lordship after the money is deposited.
44, Malad.
Which year? Which
Malad,
year?
This is the form, Malad.
This is not given
Where?
to us.
1 minute.
This year.
Where is the? You have a form on your own.
Malad,
Keep it inside your pocket. Did you give this to the petitioner or anybody who applies? You do not. When is this form handed over?
A very incomplete application. কিচ্ছু কাজ করে না, my lord. Advertisement only apply with these documents. Without any format, without any prescribed form.
See page 52, the advertisement which is shown, it mentions interested participants may apply in their letterhead. You don't say that there is an application form. It's only in the letterhead that one has to apply and which the application was made.
I do it like previous years.
Malad, kindly have a look, Malad. They have to obey all the rules and
That I have given undertaking.
fair manner.
That I have given undertaking.
On record has gone, Malad, is seeking the instructions, Malad, as to whether this was handed over to
Have you finalized the stalls?
Yes, Malad, it has been finalized.
So make place for them also because they are there for so many
Matter for
years.
tomorrow, Malad, we shall come, Monday, Malad, we shall come back with all the instructions.
Come back with the place where they will be allotted. Affidavit of service filed in court is taken on record.
Malad,
Pursuant to the publication,
Malad.
the point of I have accepted that in the last occasion because the petitioner on the last occasion did not fall within this publisher and something.
Also the same.
But here he has got something to show that there are books, there are publications and everything.
Malad, that is of
And
Vishwa Hindu Varta, not of
it
the
is the
petitioner.
same house. It is from the same house by a
They are
different
probably
name.
your loss is confusing. Malad, kindly your loss is
Same
Anandabajar Potrika. This is the Anandabajar group not.
Malad, kindly keeps it for Monday, passes order on
Don't
Monday.
say like this.
We shall come back with all instructions.
No instruction. You are going to start it, give a place for them. কি বললাম?
Start on
Pursuant to the
28th, Malad. Lordship can dispose it off on Monday itself.
yes, I'll dispose it off. Make a place for them. Pursuant to the publication made by the Publishers and Booksellers Guild, inviting applications for the participants to participate in the 48th International Kolkata Book Fair. The petitioner applied for a stall on 22nd of October 2024. Stop. In the application, it was specifically mentioned that the petitioners were participants in the same book fair for the last several years. And this year also, a place may be allotted to them. Stop. The application was kept pending. Stop. On 10th January 2025, a representation was made seeking information with regard to the application made by the petitioner. Stop. As no response was forthcoming and the book fair is due to start from 28th January 2025, the instant writ petition has been filed seeking relief. Stop. Paragraph. Learned advocate representing the
Respondents 8 and 9.
Respondents 8 and 9 submits that the application of the petitioner was not in form and the same stood rejected at the very threshold. Stop. The petitioner never approached this court on an earlier occasion and has only filed representation for the first time on 10th January 2025. Stop. It has been contended that the petitioner does not qualify the conditions required for participating in the book fair.
And also the point of maintainability.
Stop. An issue of maintainability of the writ petition has also been raised. Paragraph. From the documents annexed to the writ petition, it appears that the petitioners participated in the book fair for the last several years. Stop. The book fair is being conducted by the guild for the last several years, and the guild must be having all documents of the petitioner because the guild permitted the petitioners to participate in the earlier book fairs. Stop. All on a sudden, without intimating any shortcoming in the petitioner's application, the authority claims to have rejected the application of the petitioner. Stop. Paragraph. Learned advocate representing the guild seeks time to come ready with proper instruction as to whether the terms and conditions of the current book fair were made known to the petitioner or not. Stop. List on 20th, Monday.
One prayer, kindly it will be at the fairly at the top, so that
Yes, it's appearing as urgent motion. It will be there as urgent motion.
May I take back the rules that I've handed?
Books.
Rules.
Yes, yes.
Appear for the respondent bank, petitioner, my lord. In this case, my lord, may I just submit, my lord? In this case, the bank respondent has filed an application before the Additional Chief Judicial Magistrate Arambagh Hooghly. And after that, the learned Additional Chief Judicial Magistrate was pleased to direct to take the possession with the assistance of the police authority. And hence, the head clerk of the court was appointed subsequently as the commissioner to assist to take the possession with the help of the police authority. My lord, as per section 14 of the SURFACE Act, the rule that the legislature is clear. It has been stated in that act that according to section 14 of the SURFACE Act, the metropolitan magistrate or the district magistrate may pass the order on the basis of the application filed by the creditor. Hence, the additional chief judicial magistrate has no power to exercise and has passed this order beyond his learned court jurisdiction by appointing the head clerk. My lord, kindly come to the page 15. After followed by the order passed by the learned additional chief judicial magistrate, my lord, the possession notice was issued by the head clerk with the assistance of the police authority. And now I am handing over section 14, my lord. The bare act is here. May I just hand over the section 14?
Alert.
May I hand over the book, my lord?
Which book?
Surface Act book. Lordship of
Service Act I have over here. Criminal Procedure Code I was looking for. Yes.
This is only, my lord, I am interfering, my lord.
Let
This
that-
is the criminal procedure code. After amendment, this concept of metropolitan magistrate has been done.
Yes, well, the law is settled malad in 2021 and RDDA Act was joined company. malad. Yes.
But cause of action has arisen before enacting this act, my lord.
Malad, one more thing, malad, before malad, Lordship kindly peruse the section. Malad, may I just indicate one thing, malad? They have suppressed in their writ petition that they have approached the same reason before the DRT and order is reserved. May I handed over the interlocutory application preferred by them. In their writ petition, malad, they have not stated the same.
My lord,
Kindly consider the interim
here, my lord,
application.
what happened, my lord? That order may be reserved.
See
That
their
is,
conduct.
Did you disclose over here?
No, they have not disclosed.
my lord, at the last moment, we came to know that that order has been passed, but that has been kept reserved, my lord. But
Your client approached the RT on the self same cause of action. Has this been disclosed?
But my lord, anyhow, that client
Part or no is a different thing. Have you disclosed?
not communicated by the learned advocate who will appear, my lord, whether there is any act. Last moment, I have discovered that that order has been reserved, but no order is specific order.
Order reserve is a very last stage. Approaching is the first stage. Has
Yes,
it
my
been
lord.
approached?
Yes, my lord.
Have you disclosed?
No, my lord. On the last occasion, I came to know that an application was filed, but that has been reserved, and today is the date to take the possession.
Please come.
Kindly come to pair A, malad, the same reliefs you are seeking.
So, my lord, I don't have any scope to state to interfere the order which has been just to take the possession, my lord. Today is the date to take the possession. So I am relieved the interim relief, my lord, so that the property may not be.
Actually, the petitioner is aggrieved by certain steps taken by the respondent bank under the provisions of the Surface Act. Stop. It appears that the petitioners have already approached the Debts Recovery Tribunal for relief, and the relief by filing
interlocutory application.
interim application for stay of the operation of the order dated 21st August 2024, passed by the learned Additional Chief Judicial Magistrate Arambagh. The instant writ petition has been filed on the self-same cause of action, but without disclosing the fact of approaching the Debts Recovery Tribunal for relief. Stop. Paragraph. The aforesaid fact has been brought to the notice of the court by the learned counsel representing the bank. Stop. Paragraph. It appears that there has been gross suppression of material fact by the petitioners. Stop. The petitioners on one hand have approached the tribunal for relief, and on the other have approached this court for the same relief. Stop. The same is impermissible in law. Stop. The writ petition fails and is hereby dismissed.
I'm grateful to your Lordship.
Take back the books.
My lord, may I just submit one thing, my lord?
No submission.
My lord,
Any further submission will result in costs.
Lord, in this matter, my lord,
I have come up with an application.
my lord, I am appearing for the petitioner, my lord. My lord, kindly take your lordship's order, my lord.
Lord,
First order, my lord.
I have filed
একটু
an
দাঁড়াও।
application.
একটু wait করো। I am for the petitioner. Kindly take your lordship's first order, my lord. 5th July 2024.
Is that all?
My lord, thereafter, my lord, The matter was taken up by the Honorable Justice Tirthankar Bhattacharya and Tirthankar
I
Ghosh,
did not know that there is a judge by the name
Tirthankar
that
Ghosh,
you
my
were
lord.
saying.
My lord, my name of my orthopedics.
5th July
My lord,
24.
and his lordship was also directed to comply your lordship's order. Thereafter, my lord, my lord, I am the tortured father and mother by my son and son-in-law. My lord, I filed a writ petition before your lordship, and your lordship was pleased to direct them to file affidavit to the effect when the house will be vacated by the son and son's wife. Instead of my lord filing that affidavit, they prayed before your lordship. They are praying for some time to file that affidavit. And the next day, my lord, when the matter was taken up by his lordship, they are before his lordship, my lord, they were before his lordship, my lord, with a recalling application. My lord, I vividly objected that, my lord, at this stage it is not maintainable, it is afterthought. And today, my lord, I am also taking this point, my lord. Your lordship was pleased to direct to do something, my lord, they could not or did not. Thereafter, my lord, Honorable Justice Tirthankar Ghosh was also pleased to confirm your lordship's order. They have not complied. Instead of complying your lordship order, they have come before your lordship with a recalling application.
Very well. Let me hear today what is there in the list. The recalling application.
Recalling application. My lord,
Yes,
I have
what
filed
is the
a
matter?
recalling
My lord,
application.
one thing, my lord, I, my lord, most humbly submit, my lord, at this stage, my lord, recalling application is not maintainable because
Very
it
well.
is afterthought, my lord.
Very well.
Kindly
Let me
consider.
hear. Let me hear.
My lord.
I have
Yes.
not preferred any appeal. I have straight away come in recalling application. My lord,
Yes.
kindly visualize two
What
facts.
is the ground for recall?
My lord, two facts, my lord, I just want to place. My lord,
Yes.
in my father, I have no grievance against my parents. My lord, in the house, my lord, I was staying there in consent for last 10-15 years. At this stage, my lord, I am also doing my business out there, having a valid trade license. My lord, and I have two daughters. My lord, one is 2 years and one is 5 years. At this stage, my lord, if I am out of my house, my lord, with two daughters, I'll be at streets.
Why? You are doing business. You
My lord,
are earning.
In that house only.
Find out a place. You cannot go and disturb your
I am
parents over there.
staying in only one room. My lord, I'm
Maybe
staying
one room.
one
But then if you are in such a relationship with your parents, then nothing can be done.
My lord,
How to what extent can a father and the mother accept such type of behavior from the son or the daughter?
my lord, if anything happened, my lord, I definitely pray apology for that. But my lord, what my
It
leg-
is
my
not
lord,
your praying apology. The father is not agreeable to the children. Is it one son or two sons? I do not know. Whoever.
son, my lord, and
Son
one
and
daughter.
daughter-in-law.
One daughter is there, my lord. She is provoking, my lord. I have pleaded also. My father is totally is guided by her and her husband.
Will you please stop
This is my
interjecting?
application, sir.
Let me understand.
My lord, I have pleaded in my this application, my lord.
What does your sister do? What does your sister do?
Married.
Married, stays elsewhere.
Married and she stays at Tomdam.
Stays elsewhere. Yes. And how many rooms do you have?
Only one room, my lord.
How many rooms are there in the building?
My lord, 2, 3, 4 rooms.
Four rooms.
I am only having one, and in the ground floor, my lord, I am doing my business. My father is.
You have one room for your business and one room for staying.
Yes, my lord.
So 2 rooms.
2 rooms.
How many rooms are there in the house?
6 rooms are there.
6 rooms are there in the house. And what does the father do?
My lord, my father was running this business. Today he is, my lord, 72, 73 years of age. My lord, what I propose, my lord, if he wants maintenance or anything, but even if I leave the house, he will give the house to some person. He will
At least he will not be tortured by those persons.
The lordship may pass any order, my lord. Kindly don't throw me off from my house, because, my lord, with 2 daughters, my lord, at this stage, my lord, their right to life will go.
Their right to life will not go, because their right to life is there with their parents. The parents will take care of the children.
I don't have any other accommodation, my lord.
You have to find out if this is the behavior you do with your parents, then what can be
I have
done?
started my business in my name.
What were you doing for so long?
My lord, I was with my father's business only. My lord,
And now you have shifted out.
No, my lord, he was not.
What business do you do?
Gold jewelry.
Gold jewelry.
My father was continuing with the business.
Yes.
Today I have my trade license. My lord, I was doing my business now. Recently, my father is not in a position to look after the business. I am looking after the business. But this is the condition at this stage, my lord. If I am gone, my lord, I am totally gone. I'll be totally. That is why, my lord, I have come up before your lordship. I will not, my lord, whatever, maybe, my lord, I will make the lock and key all other portions so that I don't face with my father.
Well, let me hear your father once. The applicant is your son. There is no doubt about it. You want the son and the daughter-in-law to move out.
My lord.
What is the reason?
My lord, kindly come to my page, my lord. Page
Yes.
14, I have stated, my lord. Page 7, paragraph 7, my lord.
Yes.
And my lord, just what has been fallen from my learned brother, my lord. He is saying that he has started one business, jewelry business. My lord, so far my instruction is concerned, my lord, my advocate on record just now informed me that he is not doing any business. It is all over my business. He is always snatching money from me. My lord, he has threatened me for issuing check. My lord, everything is myself, my lord. Just he is torturing and
Are you
extorting
still
me.
continuing with the business?
My lord, I am continuing. My lord,
Do you have 1 minute? Do you have a separate place for doing business?
No,
or
my
is
lord,
it the
because
same business?
everything is my place, my lord. Everything is my name, my lord.
It's your
He is just torturing and extorting money, my lord.
No, my lord, that
My
is
lord,
not
this
a
is
fact,
my
my lord. For
specific
the 10
argument, my
years,
lord.
my lord,
Kindly
how can
record
it be,
my lord.
how can it be
If he
possible
says
for the last 10 years, my lord,
something
I am
that, my lord,
torturing?
he has a separate business, my lord, kindly do his separate business. Kindly record it, my lord. I have no objection. But I am submitting, my lord, he has
But
no
the business
separate
is yours. The
All
business
business is mine, my lord.
Trade license has already
Trade license means a license. It's an authority given to you for doing business. That does not mean that you go and snatch away your
But I
father's
don't
business.
deny the fact. My lord, my father,
I
it
do
was
not cook, my lord. My lord, most of the days, my lord, they give the lock and key in my kitchen, my lord, and they hold the key, my
these are
lord.
all bad allegations.
My
My
lord,
lord, it is admitted that
specifically I am
it
submitting,
was
my
my
lord.
father's business. I don't deny that it was not my father. It is my father. It was my father's business. I run the business.
Unfortunate
At his
father,
age,
I am
at
with
his age.
allegation upon my son, my lord.
I
have a old
understand.
father, my lord.
I
telling you about
understand.
myself. I have a old father of 82 years in my house. My fathers cannot think
The
that
allegation of the father you can see.
Yes, I can. My lord, I can. I
So
don't
if
make
this
any...
is the allegation, then what can the court do? The court has to stand by. It is his father's house. The business is his father. There is no other place. Your applicant is saying that he is running business from which place? From his father's place?
From my father's place. I don't
Then
deny the fact.
he doesn't have a separate place to do his
Kindly
business.
consider one part. My lord, I am doing the business. The business has been run for more than 10 to 15 years.
It is his business. He is you. You are
business
just
with the
taking
consent
care.
with the consent of my father.
He is taking the consent away. What will you do? You have to find out a place for your own.
At the same address, my lord, a trade license has recently been. I have taken loan. Many problems at this stage, my lord. Kindly consider.
Nothing can be done. I can extend time for you to find out a place and move out. Or at least one room. Maybe I'll take the permission from the father. If one room can be given to you to stay at least. Otherwise, no. Father torturing the son or the children torturing parents, this court will not accept.
That I vow to.
Can one room be given to the son to stay?
my lord,
Because you have got
if your lordship
two grandchildren.
My lord, if your lordship directs me, lord, them not to enter in my portion, my lord, I will select the room,
You
my
do
lord.
not have a portion of your own. It's a joint mess.
But I will not enter.
It is my property, my lord. It is subject to kind correction of your lordship. It is not joint place, my lord. It is my place. If your lordship, if it is your lordship's desires, my lord, to stay them in one room, my lord, I will convince my client, but my lord, kindly, he has to assure the court, my lord, they in future they will not disturb, my lord, by taking written undertaking before your lordship, and they will not enter.
Is there any provision for a separate entrance?
There are two entrances of the building.
There are
Two entrances.
Instruction that I have to take instruction.
Take instruction.
If possible, my lord.
If some arrangement can be made, because there are you have two grandchildren, two granddaughters, right? Now, you know how much your son can run. you throw them out all on a sudden because of certain misbehavior on his part.
Milord, kindly appreciate one thing, Milord.
I can
Under
appreciate
what
everything.
circumstances can a father, Milord, move
I can
people to
understand
another court,
everything,
Milord?
but
General people
if
cannot think, Milord. A father will file one
everybody
matter,
can
Milord,
think, I am
against son,
getting
Milord.
these matters every day. So now everybody can think. Thing is whether you can make a separate arrangement in the same house for the son and his family to stay over there. The business he'll take away. Take instruction. At the same time, you take instruction, advise your client, let him find a place for his business separately, and one room if the father can give to you.
I'll take it.
Milord,
this much.
That instruction I have, Milord. Now, Milord, at this stage, Milord, I am not willing to allow him to do business with me, Milord.
Yes, this
That,
I have
Milord,
followed.
that I have taken instruction. There,
Yes.
Milord, at the end of the pillar, Milord.
Very well. So the business has to move out.
I will try to convince my client to allot one room for them because of their small childs, Milord. That as the officer of this court, I will do, Milord. But so far business is concerned, I have taken instruction, Milord. My lord.
Yes, I
Milord,
followed.
I
The
am
father
not in
is
a
not willing
position
to permit you to do business over there. So you have to find out a place.
I have no control over the business, Milord. At this stage, Milord, though I am the sole owner.
Business, you take it out, and one room, if the father permits to stay with a separate entrance, with no connection with each other, that can be permissible. Take instructions. I'll post the matter next week. Next Friday. Next Friday. Please come. An application has been filed by the respondent numbers 9 and 10, seeking recalling of the order passed by this court on 5th July 2024. Next. The dispute is between the parents and their son and daughter-in-law. Stop. Next. The the parents allege that the son is forcefully taking over the business of the petitioner number 1 and threatening the petitioner with severe consequences. Stuff. The father is not at all willing to permit the business to be looked after or run by his son. Stuff. The father wants, now the parents wants the son and the daughter-in-law to move out of their own house so that they may live peacefully and safely in their own house. Stop paragraph. Learned advocate representing the son and the daughter-in-law submits that the applicants have 2 young daughters, minor daughters, and the applicants do not have a separate place to live. Stop. Mercy has been sought for from the father to permit them to stay in the said house. Stop. Paragraph. The learned advocate for the petitioners is directed to take instruction as to whether the applicants may be permitted to retain any portion of the subject house. Stop.
Or one room, Milord.
Any portion I have mentioned. You say 1 room, 1 tile, 2 rooms, 2 bedrooms, whatever you've got to say, you say. I am not restricting, I am not curtailing, nothing. Achha. The learned advocate for the applicants shall also take instruction from his clients with regard to clients as to whether he can maintain peace and tranquility if the parents permit the applicants to reside in any portion of the subject house. Stop. As the parents have disclosed their specific submission before the court that they are not willing to allow the son to run or look after the business in any manner. Accordingly, the son has to find out an alternative accommodation to shift his business. Stop. Paragraph. List on 31st of January.
In the event, my lord,
Grateful, my lord.
just in the event, my lord, if I have to leave the business, my lord, need some time as instructed by.
2 weeks. I have given time for both the parties to think it over and come back and report what happens.
I'm deeply obliged, my lord.
Record your appearance.
My lord, I am for the petitioner, my lord. My lord, it is that matter, my lord, where the parents of the victim, my lord, who died in an accident, my lord, allegedly in an accident, my lord, is before your lordship seeking transfer of investigation to CID or any other independent agency, my lord. My lord, on the last date of hearing, my lord, the state respondent submitted a report, thereby informing that the charge sheet has been submitted in respect of FIR number 410 of 2024. My lord, may I indicate, my lord, if my lord comes to page number 25 of the writ petition, my lord.
The charge sheet has been not submitted and report in final form. That no offense has been made out. I'll be appearing for the private respondent.
25.
24, my lord.
24.
My lord, 24 is a report, my lord, which was the report was prepared by the OC Chanditala PS Hugli, my lord. My lord, in this report, it is specified that, my lord, on the third line, my lord, seventh line, my lord, on the basis as per written information of MO Chanditala Rural Hospital, Chanditala PS UD case 61 of 2024, dated 10/6/2024, has been started. My lord, the final report is in respect of 401, which was the complaint of the petitioner alleging that the pillion rider accompanying the victim was involved due to some relationship they had, was involved in killing of the victim. My lord, that was my apprehension. I informed the police officials. However, my lord, the startling fact is, till date, the offending vehicle has not been seized. Why the accident happened?
No, you have mentioned all these things on the last
My lord.
occasion also. Now, the FRT that has been filed, is it in connection with the same case?
No, my lord, the second case, 401.
case.
No,
410.
my lord, may I say this?
No, let him place his case.
My lord, please.
He's the unfortunate mother, lost his son, so he has a right to speak.
Absolutely.
Let him speak.
My lord, kindly
Yes.
takes up the report, my lord.
Report.
My lord, the last report filed by the state respondents, my lord. There, my lord, the final report, mistake of fact number 827 of 2024 in connection with FIR 410 of 2024.
Yes.
So, my lord, this final report is in respect of the FIR.
410.
My lord, my lord, is
there a separate FIR also?
My lord, they initiated a UD case, my lord.
Yes.
My lord, there has to be another FIR, there has to be another investigation on this, my lord, as to how the victim met with his death, my lord, on the fateful day, my lord.
However, my lord, it is palpable from the conduct from the state respondent, my lord, that they have not initiated any investigation in on this basis, my lord. And my lord, I'll be relying on some judgments, my lord, which of the Supreme Court, my lord, which states that filing of the final report is not a bar from transferring the investigation to any other independent agency or the CBI in that case, my lord. I am praying for CID, my lord. My lord, may I also indicate, my lord, in the final report, my lord, the vehicle by which I suffered those injuries, the victim suffered those injuries, has been marked as unknown. My lord, this shows, my lord, how the investigation was conducted, my lord, which is very perfunctory, my lord, and my lord requires reinvestigation, or my lord, the facts has to be ascertained properly as to how the accident actually occurred, if there was an accident, my lord.
Yes.
Not first, let me say what is an UD case. Not UD case is an unnatural death case. Any death which happens on the road where the body is unclaimed for a certain time till an FIR is lodged regarding that death, a UD case is start. Whether an FIR is lodged or it is not lodged, a UD case is start. The body is sent for postmortem, taken to the doctor, Surathal report, and taken to postmortem. Subsequently, the UD case merges with the FIR if there is any FIR coming. Well, the UD case was lodged on the date when when this unfortunate event happened. Well, I am the so-called person who I was supposed to marry the victim. We are both doctors of the Dental College of Bardhaman Medical College. We had opened up a clinic at Baripur on the fateful date. Prior to that date, we both stayed together at a friend's place. On the next date, we traveled on our bike, the Royal Enfield Bullet, at the early morning when the victim was riding. I was a pillion ride. I was at the back. We were both going to Bardhaman Medical College. But subsequently, an accident happened. But I was till date the victim that present who suffered, who both were found unconscious. Now the victim also, she can't stand properly till date. She's into an extremely bad situation. Luckily, she survived. Now the mother, she has lost this FIR against us. My lord, the investigating agency went to our house. It is briefly reported in the report filed by the London State Council. They have gone to our place. They could not arrest me. I have gotten an anticipatory bail. Now they have found out that this is not matter of 302, though the allegations are. Now, when my learned friend is saying the bike was not seized, my lord, it is completely wrong. It is there in the charge sheet, and it is also there in the report that the bike was even seized and sent to the forensics, where it claims that it has been undergone a huge accident. Lordship will kindly comes to paragraph 7, page 7 of the report filed by the Learned State.
Yes.
IO received 2 reports from State Forensic Laboratory, Belgachia, so-and-so, wide report, so-and-so, dated for examination of motorcycle. bearing registration number so-and-so, received on 23/8/2024, wherein Dr. Chitrakko Sarkar, Assistant Director, State Forensic Laboratory, opined that the above noted damages of the said motorcycle are consistent with road traffic accident, where it appears that the rider of the motorcycle collided with an obstacle which was either a stationary or in a slow-moving condition. In the second report, which is received on so-and-so by Dr. Chitoleka Sarkar, Assistant Director, State Forensic Laboratory, after examination of Exhibit B, that is one sky blue color black, white and yellow colored painted full head over the helmet was also seized, the studs helmet from the front side and brown stains of places on the inside and outside of it, and opined that on the basis of the damage of helmet Exhibit B, it may be opined that due to heavy impact of the hard surface, the damages were found on the left frontal part exhibit of the helmet so-and-so. The injury was found in the photograph of Exhibit C on the forehead of the deceased. The positional correspondence and the similarity of the above injury in the fact of helmet could be found with respect to the photograph. My lord, local witnesses who had seen the accident, they were also, 161 statements were also recorded. They were made witnesses during the investigation. Now, your lordship will kindly see after filing of charge sheet, this is the last, your lordship had called for the all order sheet. These are certified copies of the order. Order dated 7/1/2025, wherein the copies of the charge sheet were filed. The learned magistrate has been pleased to issue notice upon the de facto complainant, that is the mother of the victim. Well, these two persons, the victim and the respondent.
The matter is pending.
Yes.
18th of February
Yes.
2025 is the date you have whether to accept the charge sheet or not. So you can always make your submission over there.
They can file an RRG petition if they
Yes,
so wish.
wait.
My lord, my core allegation is against the state police respondents, my lord. The crux of it is that they have failed to investigate if there was an accident. How did that accident happen? My lord, today, my lord, the private respondent is saying that the UD case merged with the FIA.
No,
My lord,
forget what the private respondent is saying. Things are there. The report of the state is already on record. I see the date has been fixed by the learned court below, where you have been given notice for appearing.
My lord.
Why don't you make all these submissions over there?
My lord, I require a change of investigating agency, my lord. My
You
lord,
can make this prayer over
my
there
lord,
also.
if my lord, I make this prayer before that, the investigation will be transferred to the Chandidala police station, my lord. Then again, I'll have to again file another application seeking, my lord, change of investigation, my lord. My lord, during this time, my lord, a lot of time will be wasted to retrieve the fact that whether the accident took place or not, or whether the vehicle involved can be traced back or not, my lord. My lord, they have
But
not.
thing is, still the charge sheet
lord,
is
I have-
placed before the court, and
My
the
lord, it
court
is not a
accepts it.
my lord.
The court can very well say, no, I am not accepting it.
My lord, however, my lord, we are here for change of investigation, my lord, and my lord, this cannot be a bar, my lord. I have a judgment, my lord, of the Supreme Court, my lord. Kindly takes it up.
I understand, but had it been a case that where the lower court accept the charge sheet, then this could have been
My lord, this is
looked
not on
at.
this is not on the lower court accepting the charge sheet, my lord. This is on whether filing of the charge sheet can be a bar to transfer an investigation to any other
You can
independent.
apply this over there also.
My lord, there, my lord, I'll be severely prejudiced, my lord, because, my lord, a lot of time has been passed, my lord. My lord,
This is 18th of February,
my lord,
right? You can seek for preponing it.
my lord.
Today we are already on the 17th of January,
My lord.
right? A month to go.
My lord.
Either you wait or you can prepone it, because the charge sheet possibly was submitted when? Yes, so 1 month prior, last month it was there. You did not get notice of
My
that?
lord, we have
My
not
lord, it
received.
was submitted before the
We
learned
had not
court below on
received, my
7th.
lord. It was submitted on 7th, my lord. My lord, I am challenging the conduct of the state police respondents, my lord.
Followed it.
My lord, where they have conducted an investigation in complete violation of their duties, my lord. Therefore, my lord, an independent agency is required for the investigation, my lord, of the facts and circumstances arising out of this application, my lord.
May accept it or may not be accepted.
Provisions under 173 subclause 8.
My lord, the investigation was not fair, my lord. My lord, kindly takes up the charge sheet,
My
my
lord,
lord.
we'll just go through for once.
Thing is,
my lord,
my lord,
the magistrate has enough powers
yes, or another
to call
old act,
for
70.
reinvestigation. ought to direct the direct change in the investigating agency.
My lord.
The magistrate can do it. I'll give you leave. You go and approach over there.
My lord, my lord, kindly.
Please come. Yes.
Will your lordship also consider this, my lord? I have the medical documents of the respondent also.
You may have medical documents, but see the agony of the mother.
I understand, but my lord,
Please,
your lordship will kindly see the agony of me. We were supposed to
lord,
get married.
Kindly one
And the
indication.
allegation is against you.
No, that is the fact, because you, my lord, let me, my lord, apprise your lordship.
No,
one
no,
thing.
it's better not to.
My lord, may I indicate something, my lord? My lord,
From the report
one
filed
indication,
by
my lord.
the state respondents, it appears that a charge sheet
My lord, it's an FRM,
in the form of final report, mistake of fact has been filed. Stop. Date has been fixed by the learned magistrate on 18th February 2025, and notice is to be issued upon the de facto complainant, the petitioner herein. Stop. Paragraph. The petitioner the petitioner submits that the investigation has been done in a perfunctory manner. Stop. Very vital pieces of evidence have not yet been collected from the custody of the petitioner, who lost her child in the accident. Child is, I guess, son. In the accident. Stop. Next. The petitioner prays for change of the investigating agency. Paragraph. Learned advocate representing the private respondent opposes the said prayer. Stop. Paragraph. Upon hearing the parties and on perusal of the documents placed before this court, it appears that the learned magistrate has already posted the matter on 18th of February 2025 upon notice to the de facto complainant. Stop. It will be open for the de facto complainant to address the court with regard to the issue of with regard to the prayer for change in the investigating agency and the loopholes in the final report that has been filed. Stop. Paragraph. The magistrate shall take a decision in the matter upon hearing both the parties. Stop.
Not all the
Will
parties.
be
That's
all
it.
the parties. Stop. Next. It will also be open for the petitioner to seek for preponement of the matter, and the learned magistrate may consider such prayer provided consider such prayer as per the convenience of the business of the court. Stop. The writ petition stands disposed of.
Can you record? I have filed my report last October.
Yes, yes. It's already there. It's recorded that your report is on record.
The certified copy may be kept with the record. The
You
audit.
can take it back. Did you file your wakalatnama?
File করেছি কি আমরা? হ্যাঁ, it has been filed in the department.
Lord, we are for the state. My lord, I appear for the petitioner. This petition, my lord, pertains to my lord, police inaction. The first round of litigation, my lord, the elder brother, my lord, initiated by filing writ petition, my lord, against the private respondents. My lord, the actual aspect involved in this case, my lord, the petitioners are enjoying their, my lord, paternal property and doing their cultivation over the land. My lord, a partition suit is pending before the Landed Civil Court of Law, and order of injunction has been passed. Still then, my lord, the private respondents, my lord, used force So that, my lord, the petitioners cannot, my lord, cultivate their over their land. So, my lord, kindly have a look, my lord, page 83 of my writ petition. My lord, this is the,
Is this a assigned matter?
my lord. My lord, assigned matter, my lord.
Assignment.
And assigned by name or by jurisdiction?
Lord,
that
assigned on, Lord, on 25th November, my lord.
25th
Lordship
of-
has heard the matter. I have already filed my report, my lord, on that date, 25th November. And same also, my lord, served to the petitioner.
Yes, assigned.
My lord, kindly have a look to, my lord, annexure P1, page 59. So this is the, my lord, record of rights showing that our predecessors were the, my lord, owners of the land.
Page 59.
Page 59, my lord.
Yes.
Annexure P1, my lord.
Right.
But this is the record of rights, my lord. In the record of rights, you lords will find, my lord, right.
Nobody representing the private respondents?
Lord, nobody is appearing, lord.
On the last occasion, my lord, the service has been made properly pursuant to your lordship's direction, my lord.
Where is the affidavit of service?
My lord, I have filed on the last occasion.
Last occasion affidavit of service, yes. All right. What is your case?
Well, kindly have a look, my lord, page 59, my
59.
lord. Lordship will find, my lord, that right is Vidya Rao, my lord, the predecessor of the petitioners, my lord. Thereafter, my lord, Lordship kindly have a look, my lord, page annexure P4, page 72. This is, my lord, the first complaint lodged by, my lord, the elder brother of the, my lord, the petitioner, my lord. My lord, it is, my lord, addressed to the inspector in charge, Topon Police Station, Dokhin Dinajpur, dated 28 July 2022. Darkhastokari Dinesh Baha, the elder brother of the petitioner, and, my lord, the Bivadi, that's, my lord, the name of the, my lord, private respondents. Here, my lord, the brother of the petitioner stated everything, and, my lord, requested for, my lord, police help so that they can cultivate, my lord. My lord, police, my lord, did not perform their statutory duties. As a result of, my lord, the petitioner's elder brother was compelled to file a writ petition, my lord. Kindly have a look, page 82, 83 of my writ petition. This is the first writ petition filed by the elder brother of the petitioner. My lord, page 84, your lordship will find that, my lord, Justice Rajshekhar Mahanta, my lord, recorded the, my lord, undertaking of both the parties that they will not, my lord, create any disturbance over the suit property and shall maintain absolute peace and not to resort to any violence. The petitioner may take out civil proceedings in support of their civil grievances against one another. Lord, my grievances is, my lord, that so far the, my lord, claim of the title or other things, my lord, that is pending before the civil court of law. Well, injunction order has been passed. Now, my lord, if, my lord, the private respondents, my lord, used force, my lord, whereupon we are in possession, we are, my lord, doing cultivation, that is our main grievances, to resist the private respondents from using force. Because they are, my lord, coming with deadly weapons, lathis, other, my lord, weapons, and threaten the petitioners and their family members. So, my lord, including, my
His
lord,
complaint is, my lord, on page number 107, my lord.
What steps did you take?
My lord, 126 has been initiated, my lord, because, my lord, it is the long-standing dispute between the parties for the civil in nature, my lord, from 22 to since, my lord, 24. So, lastly, my lord, he has complained to police, page 6 of my report, my lord. On 25, I have already, police has initiated 126 of the BNSS Act.
No, but then only invoking sections will not do. The private parties are going and applying force, and the police is
Case and counter
sleeping.
cases are filed by the each of them, my lord.
Yes. It is for your duty to
See
maintain
the
peace.
107, my lord. 107 of the complaint of the my writ petition, my lord. Long-standing disputes, my lord. If lordship will start vigil over the disputed land, because, my lord, right title and interest is not established.
Please come.
Hello, I'm not surprised that civil suit is.
None represents the private respondents. Stop. Next. the petitioners allege forceful conduct on the part of the private respondents in preventing them from cultivating certain plots of land. Stop. Paragraph, it appears that the petitioners and the private respondents are co-sharers of certain plots of land. Stop. Paragraph. No, paragraph, no, Shati. For adjudication of their respective civil rights, comma, civil suit is pending before the learned civil court. Stop. The petitioner alleges that the private respondents are forcefully restraining him from cultivating the land which is in his possession. Stop. Paragraph. The court on the earlier occasion directed the parties to maintain peace and tranquility. Stop. Paragraph. The police is bound to ensure that there is no breach of peace and tranquility in the locale. Stop. As regards the portion of the land the party is occupying for cultivation is an issue to be decided by the learned civil court. Stop. It will be open for the petitioner to approach the learned civil forum to obtain specific order of injunction in respect of any particular plot of land which he claims to be in possession of. Stop. The police will not decide upon the possession of the parties, but will only be responsible for maintaining peace and tranquility in the locale. The writ petition stands disposed of. Then 12 নম্বরটা দেখুন তো।
Item number 12, my lord, it is bonded, my lord.
Petitioner is not here. Dismiss for default. None appears on behalf of the petitioners on repeated occasions. Stop. No accommodation sought. Stop. The state is represented. The matter stands dismissed for default.
If it can be taken up on Monday, affidavits are complete exchange.
Who is for the petitioner?
My lord, I appear for the petitioner. My lord, my learned friend wanted it on Monday. My lord, my humble request would be, could it be on Tuesday, my lord?
Very well, Tuesday.
Obliged.
নিচে মঙ্গলবারের দিনটা দিয়ে দেবেন।
I'm grateful.
Deeply obliged.
I'm for the private respondent, Lordship.
Where is the petitioner? Dismissed. Record presence of the respondents.
Honorable Sita report in compliance of my lord.
My lord, I have filed
Are
my
you aware of this report?
My lord, I have filed my reply. My lord has been very kind to take my reply on record on the last occasion. My lord, this is, my lord, a matter where, my lord, my clients, my lord, were granted, my lord, a contract for relaying of 400 meters synthetic track, my lord, of Sports Authority of India, my lord, at the Kolkata complex. My lord, this was, my lord,
certain payments is due to you.
Yes, certain payments are due. And, my lord, in course of deliberations, my lord, before this honorable court, it now transpires that, my lord, the customs duty, my lord, the exemption, my lord, which was disallowed by the customs authorities, my lord, that, my lord, has become, my lord, a bone of contention. Now, the PWD, my lord, who has issued the tender, has in its report said that it is the duty of Sports Authority of India to provide for the exemption and ensure that the customs duty is allowed. And it is also stated in PWD's, my lord, affidavit that this has been given to them much after the work has been completed.
What thing?
My lord, the customs duty exemption. My lord, kindly comes to, my lord, page 157.
Yes.
My lord, kindly sees this is exemption from payment of customs duty, import items so and so.
Hmm.
My lord, this is dated 4th April 2018.
Hmm.
My lord, the tender, my lord, is of 17th November 2017.
All right.
Now, this, the PWD says that it has come to them only in 2020. My lord, kindly now, my lord, takes up state's report.
1 minute, page this 4th April's communication is made by Sai to the Commissioner of Customs.
Yes.
With a prayer for exemption of payment of customs duty. Right?
Right.
It is not for you to take up the matter?
No.
The Sai has taken it up with the customs authority.
My lord.
Contract is between Sai and the PWD. Sai has given the contract to you.
My lord.
This
My
is
lord.
the case.
My lord. Lord, I am nowhere, my lord. There is no privity of contract between me and Sai. Lord, I have, Lord, completed the work. Lord, the completion certificate has been issued. Lord, the defect liability period for refund, Lord, is 5 years. That 5-year period is over, yet my security deposit and earnest money has not been, Lord, paid to me. That is, Lord, my first demand. My second demand is with regard to the unpaid amount of dues, which my lord would very kindly, my lord, find, my lord, is admitted at page 173. I will not trouble your lordships, my lord, since, Lord, I find my lord is in
the balance
absolute
amount,
recollection of the facts.
75 lakh is due.
My lord.
Right?
My lord.
The government says.
Yes.
And the payment has to come from Sai.
The payment has to come from side insofar as PWD is concerned, which is not my botherance, because page 34 is the tender issued by PWD. Page 34. Lord, very briefly, my lord, I take my lord through the pages, my lord, relevant. Page 34, my lord would find, lord, this is lord 17th November on the right hand side top, my lord would very kindly find. And then the relevant part of this is lord the nature of work, which my lord would find in the first column on the left hand side. Relaying of 400 meter synthetic athletic track at Sai. And in the extreme right column, my lord would find defect liability period is 5 years. Now, my lord kindly comes, my lord, to straight away, my lord, page 46.
Show me the terms of payment over here in the
Yes.
contract.
Yes, my lord, I come to that.
There are but two rates.
One
One
minute,
is
one
with
minute.
custom and another is.
1 minute,
without
1 minute. Yes.
My lord, I come to that. My lord, I'll come to that. My lord, kindly comes to page 46. There will be a defect liability period of 5 years. My lord has very kindly found it, my lord. And the security deposit will be released phase-wise as detailed below. Then prospective bidders will have to execute the work in such manner so that appropriate service level for the stipulated stretch length of the road under improvement is to be maintained under the stipulated contractual period for a period of 5 years. And the next page, my lord, is, my lord, kindly sees D.
Yes.
The manner in which, my lord, the security deposit is to be
Refunded.
disbursed.
Yes.
For work with 5 years defect liability period,
Yes, yes.
I showed, my lord, this is 5-year defect liability. No security deposit will be refunded to the contractor for first to third year. Then 30% of the security deposit shall be refunded to the contractor on the expiry of 4 years. And then the balance 70% security deposit shall be refunded to the contractor on the expiry of 5 years.
You have not received anything.
No. Now, my lord, kindly, my lord, comes to, my lord, page 49. My lord, kindly sees, my lord, serial number 28, para 28. This is a time-bound urgent work. But in view of the sports event, my lord, ensuing then, this was not to be executed on urgent basis. Now, my lord, kindly, my lord, comes to page, my lord, 142. But this is not the work order. But kindly sees estimated amount put to tender is so and so, accepted rate is so and so, and the tender amount, my lord, kindly finds 686, 56, 188. Right hand side top, my lord has very kindly found it, my lord. And then at the bottom, my lord, on the left hand side, immediately, my lord, above the word enclosure, this may be treated as a formal work order. My lord, kindly comes to, my lord, page 156. My lord, this is, my lord, akin to page 157, which I showed to my lord, that Sports Authority of India is writing to the Customs Department that they are giving exemption to this and they are asking for grant of custom duty exemption. They approve it. The Customs Department is to give exemption. But finally, I shall show documents, which would go to show that despite this having been approved by Sports Authority of India, Customs Department declined to grant customs duty exemption. Now, my lord, kindly sees, I need not show page 157. Kindly, my lord, sees page 158.
And the figure that you read out in the work order,
my lord,
right? What has this got to do with the customs duty?
My lord, this is inclusive of the customs duty paid by me.
All right. You have paid the customs
I
duty.
have paid the customs duty. This is an admitted position.
Yes.
Now, my lord, kindly sees, my lord, page 158. My lord would find, my lord, nature of work. The first work is relaying of 400 meter synthetic athletic track. My lord, part payment made, my lord, is this.
kindly also see, my lord, the next work. This is relevant for the purpose that in respect of this laying of synthetic hockey track, my lord, some, my lord, exemption was required. That exemption also could not be obtained, and Sports Authority states affidavit says has disbursed the entire amount inclusive of the custom duty.
In whose favor?
In the successful tenderer in respect of the hockey synthetic
Hockey
track.
track. You are for the athletic track.
I am for the synthetic track.
Right.
I am athletics.
Hmm.
Now, my lord, kindly sees, my lord, page 159. When I find that the work is of urgent nature, but I say that the customs duty exemption has not yet been granted. I have to now proceed. So I intimate them that I am proceeding without the exemption. But, second paragraph, we wish to bring to your kind attention that Customs Department is not agreeing to duty exemption letter, which I showed, Milord, 156, 157, and having lot of observations. So we will go ahead and pay the customs duty to avoid demurrage and detention. Our clearing agent and clearing team is on the job over the last 15 days plus, but further delay will cause a lot of additional expenditure. I will not intimate the PWD. Milord, kindly, Milord, comes to Milord, page 163. Milord, this is Milord completion cum performance certificate.
No, they do not say that you have not completed your work successfully or anything of that. So it is the customs exemption, which is just standing in the way of releasing payment or something.
Milord, I am only showing, Milord, I am very, Milord, in short, Milord, taking, my lord, to the relevant, Milord, part of it as to how much payment has been made. Milord, kindly sees here, serial number 8, payment made is 60994,423. This is, Milord, which is, and Milord, the comments in serial number 11 III on the capabilities of the contractor are all very good. So, Milord, there is no objection with regard to my work. Milord, kindly now, Milord, comes to Milord, page 172.
What is the stand? Why is PWD not making payment?
PWD, Milord, petitioner has been paid. As per, Milord, there are two rates.
No, paid only 6,09,000.
Yes, Milord, kindly see, Milord, come, Milord, page 147. There are two type of rates, with custom duty and without custom duty. Now, petitioner has been paid.
1 minute, 147.
Yes,
147. Yes.
My lord, 401.
401.
That is, my lord, the rate item includes custom duty. And 402. So the rate will be, my lord, the lesser, but we have been paid the higher with custom duty. Now the SAI is not releasing this, but in case of other case, the SAI has released the custom duty with custom duty.
SAI is to release it in your favor.
Even, my lord, unless my favor is given, how can I, my lord,
So you fight it out with them, but then you have a contract with the petitioner. Why will the petitioner doesn't have any contract with SAI?
My lord, this contract comes from the SAI. SAI will pay us and we will pay them. Unless the, my lord, unless the SAI paid, well, it shall not be paid from our pocket.
Why you have issued the work order to the petitioner?
There are types of rate. If there are two types of
whatever
if
the rate,
highest rate is given, then unless the security deposit, if the security deposit is given to the petitioner, then how it will be recovered? And my lord, I have given the instance. If you are not,
where is the question of recovery?
my lord, because my lord, the without custom duty he has paid. He has not paid with custom duty. He has not cleared the custom duty money.
The petitioner has paid the customs duty.
No, he's saying SAI.
SAI. My lord, SAI.
The petitioner has put in the customs duty?
Yes.
Yes. But custom duty clearance is not given.
It is for y'all to look into it. Why will this person suffer?
If your lordship, my lord, kindly come in my report, particularly, my lord, the paragraphs.
And it is for you and Sai to take it up with the customs authority. Why will the petitioner suffer? Even the security deposit, after the defect liability period is over, you are holding it back. Why will people do business in West Bengal, will you say?
My lord, if your lordship kindly come, my lord, few paragraph from my affidavit in opposition, my lord, the report.
Which paragraphs?
From paragraph 18.
Yes.
It is stated that the Sai has disputed the final bill amount of the agency with custom duty and requested the executive engineer to refund 55,76,881 as excess fund towards the custom duty. A demand by Sai, if the bill has to be finalized considering rate with the custom duty exemption, final bill amount will be reduced to 5,53,30,800. It is stated that the payment has already made to the petitioner, the agency, 6,09,94,000 and some odd. Hence, the security deposit along with the earnest money cannot be realized until the settlement of the dispute. If the claim of the Sai for payment of with custom duty exempted rate prevailed, then the amount would have to be recovered from the security deposit and the earnest money lying with this office. Security deposit and the earnest money
In the contract itself, is there any
kindly see my lord paragraph number.
Is there any provision for settlement, in-house settlement of dispute?
No. The agreement says that there would be no arbitration.
And my lord,
how will the issue be settled?
If your lordship kindly come, my lord, paragraph 24.
Tell me, an issue has been raised by your authority. How will it be settled? The petitioner will be without payment.
My lord,
Or will you?
My lord, I am praying for direction upon the Sai to take a decision.
Sai is not a party over here.
Yes, Sai is party.
Oh, Sai is a party. The customs is not a party over here. Right. Sai is a party. Sai cannot unilaterally take a decision.
In the similar work which custom duty has paid in other cases, but in this case he is not doing it. I have given the example.
Which example?
My lord, if your lordship kindly come.
Hockey track.
Hockey track. All right.
Let the Sai be directed to my lord.
What is the stand of Sai?
By Sai.
Yes.
Paragraph 1. That in terms of the order dated 8 November 2024, passed by the Honorable High Court, the Court of Justice of India was directed to file an affidavit disclosing the proper facts.
Who is the on record? Fact sheet is in the name of?
Name of HON'BLE.
Yes. Page?
First page.
First page.
Paragraph 1, you're not disclosing the proper facts and figures, including the timeline for payment to the petitioner. In this regard, it is submitted that the Director and Infrastructure of India allocated funds for drilling of 400 meter synthetic athletic track at Netaji Subhash Distance Center, Regional Center, Kolkata, upon proposed estimated cost of ₹610 lakhs. On account of that, the West Bengal PWD submitted an estimate of ₹686.60 lakhs by memo number so and so. And accordingly, the PWD was given approval to start with the tendering process by office letter number 20. The PWD floated tender and Mrs. Gates Tech Limited was shortlisted to perform the drilling work on an estimated cost of ₹686,89,532. So in 2 days, the PWD was paid ₹1 crore 22 lakhs on 16/1/2018 and ₹4.88 crores on 1st January 2019. Vice President.
Listen.
Another paragraph is very important. 3 and 4. Kindly see. This is the stand of this heart. That public money cannot be wasted this way. Kindly think that what is the stand taken by the side?
Yes.
That the subject matter of exemption by the Custom Department to the West Bengal PWD and to the vendor Mrs. Great Sports Authority Tech Limited for purchasing raw materials can only be answered by the Customs Department. Unfortunately, the Customs Department has not been added as party respondent. As far as the custom exemption is concerned, the Sports Authority of India can only issue exemption certificate for waiver of customs duty, and it is in the West Bengal PWD and the vendor Mrs. Sports Tech Limited to place it before the Customs Department for exemption. Yet, as far as the timeline for making payment to vendor, the Sports Authority of India has already made full excess payment to the West Bengal PWD.
What do you mean by full and excess?
Because if the custom duty exemption is obtained by the PWD or the petitioner before your lordship, then it will be excess.
The petitioner cannot obtain. It has to be obtained by the PWD.
That's correct.
Petitioner is not in a position.
We have not tendered the entire contract to the PWD. They have executed through the petitioner.
Yes.
So it is between PWD and the petitioner.
But the payment has to come from you.
We have done. We have done. Your lordship has seen. We have.
Listen, fact remains an issue has cropped up with payment and it has to be resolved. Will your authority take a decision? You all can sit with the PWD officials. You can request the petitioner.
My lord, I have arranged the document in respect of the Hokita. That, my lord, in that case, my lord, with custom duty, first
Yes.
they have raised
Yes, please. Right.
Let the custom authority be represented, everything would be resolved. Why they are not making the exemption? Because
thing is, this will only expand the scope of the writ petition. The petitioner has got nothing to do with customs. The petitioner has a contract with PWD, payment has not been made, the writ petition has been filed. It is as simple as this.
No,
but
they have sought for exemption from the custom authority also.
I have followed it. What steps have you taken to follow it up with the customs authority?
If your lordship sees the affidavit filed by PWD, they have also kindly see paragraph 9.
Yes.
Paragraph 9.
They also say they request for the exemption.
Yes, it is the stand of the PWD, kindly see.
And the excess money we have paid to the side, each furniture the excess 55.
The stand of the PWD West Bengal with regard to exemption of custom duty, kindly see paragraph 9.
Customs is also a government authority. You are also handling public money. Listen, the petitioner cannot be left without any payment. Now, if the custom says that I am not going to exempt, what is to be done?
That is the reasons are to be sought from the custom authority. Why
it is for you. It is for you to seek reasons.
No, but it has to.
As on date, customs has not granted this exemption. As on date, it is not granted. Right? So in that case, you have to make payment. If is a long thing. Nobody knows whether this if will happen or not.
If the exemption is provided.
If it as on date, it is not provided.
They have declined. Page 218 of the writ petition.
As on date, not provided. What is to be done? You have to make payment.
In that case, that's why I am just not insisting upon your lordship not to go for the custom.
The issue whether the customs properly declined exemption or not is not to be decided over here. It is for you to take it up with the customs authority. It is you who is raising this dispute. As on date, there is no exemption. Why will the petitioner not get the payment? And it is the petitioner who has paid the customs duty.
Petitioner has paid, but
then
it is to be the PWD, the contractor. PWD has to chase for obtaining it from the custom authority.
The PWD is not chasing it. It is you who will chase it. It is you who got the work done.
That's correct. But
it is the payment has to flow from you.
Payment, whatever was required to be paid, that has been paid.
Sorry, sir. The court cannot accept your contention.
Kindly see the stand of the PWD.
I have seen the stand of the PWD. PWD says customs duty has not been exempted.
Exempted and not paid, and similar cases the Sai has paid.
And you have paid.
I do not have any instruction with regard
But
to
I have annexed with the documents.
It is for you to take
I
instruction.
have annexed with the documents.
Why will the payment not be made?
In the present case, Lord, we were definitely liable to issue certificate with regard to exemption for custom duty.
Listen, you are repeating the whole thing over and over again. The court's time is extremely precious. You have got the work done. Payment is to come from you. Customs, as on date, has not granted any exemption. So it is you who has to bear the charges. Now the payment has to come from you. How soon can you do it? Thereafter, you get reimbursement from the customs authority. Why will you make the contractor who has performed the work not pay? Why will be he left without payment? No kindness to be shown. Sorry, sir. Exactly. This is public money. Go and chase the customs authority and get it from them. Why will the payment not be made to the petitioner?
Custom authority can easily be.
You can.
Custom authority can easily be implemented in the petition. Let them come and submit it for lordship. Why they have declined? That is my only stand.
Your stand in a different petition, not here. I want the payment from your side to come. Please come.
Lord, only one submission, Lord, I make. Lord, when this customs department were not granting exemption, there was, Lord, a tripartite meeting. After that, Lord, at page 218, customs department declined. So the customs department has declined to accept.
Indication of declining the offer, and you say, why will they decline? Is that the issue?
218.
There is no provision in the contract that we have to pay the custom duty. But there is
Two rates in the contract, yes. Two rates are there.
That we are liable to pay
Yes,
the custom duty. Let them so.
157, there are two type of rates. One is with custom and
you have accepted the rate that has been given by the PWD. And now you cannot say that, no, I will not pay the customs duty. You cannot do that.
Certificate for exemption.
You issue it, dip it in a glass of water and keep it with you. Achha, the petitioner was awarded contract by the Public Works Directorate, Government of West Bengal, for relaying of 400-meter synthetic athletic track at Sai space NSEC, Salt Lake, Kolkata. The estimated amount put to tender was rupees 6 crore 66 lakh 88,866 only. Stuff. The period of completion of the work was 90 days from the date of commencement, and the defect liability period was 5 years. The security deposit to be paid by the contractor was to be released in a phase-wise manner. Stop. No security deposit could be refunded for the first to the third year from the actual date of completion of the work. Acha, uta kore din, contractor, within the first 3 years from the actual date of completion of the work, comma, no security deposit, bolam to, shall be refunded to the contractor within the first 3 years from the actual date of completion of the contract, comma, 30% of the security deposit to be refunded on expiry of 4 years from the actual date of completion of the work, and the balance 70% of the security deposit is to be refunded on expiry of 5 years from the actual date of completion of the work. Stop. The work in question was completed within the stipulated time period. Stop. Part payment has been made to the petitioner, but balance is yet to be paid. Stop. The security deposit has not been released despite completion of the 5 years period.
As also the earnest money.
Stop. The earnest money deposited by the petitioner has also not been refunded. Stop. Paragraph. According to the certificate issued by the chartered accountant of the executive of the PWD, the balance to be paid to the petitioner is rupees 75 lakh 69,446 only, as on 13th of August 2019. Stop. The petitioner seeks payment of the contract amount, as also the security deposit and the
Earnest money. Earnest money.
earnest money. Stop. According to the terms and conditions of the contract, there is no in-house provision for resolution of the dispute regarding payment or otherwise. Stop. The petitioner has approached this court for relief. Paragraph. The PWD and the Sports Authority of India has filed their respective affidavits before the court. Stop. Paragraph. According to the Public Works Department, Directorate, not department, কি বললাম? No, the report of the PWD clearly, not report, the affidavit of the PWD clearly indicate that there is a dispute with regard to payment. It mentions that Sai has disputed the final bill amount of the agency with custom duty and requested the executive engineer for refund as excess fund towards custom duty was paid. If the bill is to be finalized considering the rate with custom duty exemption, the final bill amount will be reduced to rupees 5,53,30,800. Instead of rupees 55,76. No, will be reduced to such and such. Stop. Shudu 553 of the third bill. The payment already made to the agency is rupees 6,09, 94,423. Stop. According to the PWD, the department is not responsible for obtaining the custom duty exemption, which is the primary responsibility of SAI. And PWD has declared that the SAI has withheld the amount of rupees 1,32,33,069 to the agency, considering the rate per square as rupees 6,877, which includes custom duty. Stop. SAI has not released the balance payment on the plea of not obtaining the custom duty exemption. Stop. As SAI has not released payment in favor of PWD, accordingly, the PWD is not in a position to release the amount in favor of the petitioner. Stop. From the report, from the affidavit filed by SAI, it appears that now in the affidavit filed by SAI, it has been mentioned that the authority receives customs exemption on raw materials imported from outside India, and accordingly, request was made before the customs authority praying for exemption of customs duty on the money paid by the petitioner on account of the materials purchased. Stop. If the exemption is granted by the customs authority, then the rate to be paid to the petitioner will be substantially reduced. Stop. According to the learned senior counsel representing SAI, public money ought not to be squandered in such a manner. Stop. Next. Paragraph. From the documents annexed to the writ petition, it appears that the customs authority has refused to grant exemption
of the customs duty in respect of the materials purchased by the petitioner for laying the synthetic track. Stop. Once the customs authority has refused the exemption, the same implies that SAI is required to bear the charges on account of customs duty. Stop. The affidavit of the PWD clearly indicates that SAI had paid for the customs duty in respect of the hockey track that was laid. Stop. Paragraph. Whether the act of the customs authority in refusing to grant exemption of customs duty is not an issue to be decided in the instant writ petition. Stop. In the present case, the petitioner seeks payment of the work performed by it in accordance with the work order stop the completion certificate issued by the competent authority makes it evident that the work performed by the petitioner was satisfactory. Stop. The defect liability period is long over. Stop. There is no plausible reason as to why the payment will not be made in favor of the petitioner. Tell me one thing, what is to be done? Is the customs to be included as party? Because I'm sure
Later, my lord, the SAI will take steps.
Your customs has declined. Page 218, customs
has
said
declined.
yes. So now it is
taking it up with the customs will not improve the matter in
it
any
is
way.
now between SAI and customs. SAI can always ask customs, but it is one, the sports department, Ministry of Sport and Youth Affairs, and others, it is Finance Ministry. It is in between them. The money is with the government, whether it is in the left hand or the right hand. The question is not that. They just a second. Now, customs, once it says that we are not going to pass any reasoned order. So this can be taken up only by the sports authority because it is on their certificate that the customs has declared.
I can understand this, but this is the clear stand of the sports authority that they will not take it up. They will merely hold back the money, right? So,
there were tripartite meetings between the sports authority, the PWD, and the petitioner 3 times. And each time, it was said that the PWD and SAI are pursuing with the customs authorities. Kindly see for a moment, page 218, it will resolve the issue. Finally, Customs Department informs me that I am carrying a deadlock. I must abandon it. Page 218.
218.
I say the copy of assessment speaking order. I was instructed to ask for this from the Customs Department. Now, under compulsion, I sought for it. They say, please refer to your letter dated so-and-so. In this regard, as per instructions of the customs dated so-and-so, the proper officer shall pass a speaking order on so-and-so within 15 days of assessment, a bill of entry or shipping. It is a matter of long pending at your end. Accordingly, on the basis of said circular, After 15 days, no speaking order and disposed of. So they have nothing now in their record to decide. Although I was not required to ask for it, but since in the meeting, which is at page 234 onwards, 234 to 237.
No, I understand. But since this amount is being disputed, right? Issuing a writ of mandamus to get it implemented, how far the writ court can enter into? This is what is troubling the court.
Milord, only one thing, Milord. My
Yes.
privity of contract, Milord, is with PWD. Milord, that a contract was silent as regards, Milord, this issue. It provided for 2 rates. When the custom duty exemption was not obtained by PWD, Milord, I proceeded, I intimated them. I completed the work satisfactory. And then, Milord, kindly see, Milord, for a moment, 197. When have the customs duty clearance, Milord, was given by Sports Authority to PWD? Milord, kindly come to page 197 for a moment. After the work, Milord, has been completed, 198, I'm sorry. Last but one paragraph starting with the word astonishingly. My lord has very kindly got it, my lord. 198.
Yes.
Last but one. Astonishingly, on 22nd September 2020, that is after 2 years of completion of work, in charge so-and-so of Sports Authority, Mr. So-and-so, with a letter is stating that the director, Sai, Kolkata, had issued valid exemption certificate to the Customs Authority. So after the work is complete, when is the customs clearance certificate required? When I am getting the goods cleared from the customs house. PWD says that in 2020, the work is completed in 2019, long back. And then at page 218, when they ask me to pursue the matter with the customs authority declines. So the certificate which of approval given by SAI, based on which the customs department were to exempt imposition of duty, that has not been respected by the customs department. And I have, my lord, written letter to the PWD intimating them. My lord, I have shown it to my lord. I once again, my lord, at the risk of repetition, my lord, show it to my lord.
No, instead of showing this,
yes,
I was thinking if you can come up with some judgments.
My lord.
I read a recent judgment of the Supreme Court where it has been said that only if a dispute is raised in a money claim does not mean that there is a dispute.
That is ABL International, my lord, again.
ABL is the old one, but it has been repeated in the very recent.
Krishna Logistics.
Very recently, it has been.
Krishna Logistics, it upholds, it relies on it.
Yes. 1 week back.
It relies on ABL.
It relies on ABL. Yes. No. It is not that only if you raise a dispute, it means that a dispute is there. You are trying to raise a dispute where there is no dispute. This is where the distinction is. No, once you dispute, how can the claim be admitted? It's not that. You get that recent judgment. I have dictated a portion of the judgment. I have made my mind clear.
My lord.
But then I would like to fortify my judgment.
My lord.
So that
I'll come with both the judgments.
It can stay on. Otherwise, you'll go on moving from one court to the other.
I understand. Well, I shall.
Right.
I shall come back.
Yes, just a week back it came out.
And my lord.
And starting from ABL only.
Yes.
My lord, lastly, my lord, 2024.
Yes.
My lord, the PWD department issued several letters to the my lord SAI to release the amount. My lord, that is my lord, the last is 270. Kindly see the my lord, page 270.
You are pursuing with SAI, but not taking any legal step. Fact remains that this person has done the work, but is not getting the money. If you cannot obtain money from this authority, you say you cannot pay. Now it is between two authorities and the petitioner is sandwiched.
He is victim.
So he has to be, you are supporting the petitioner.
My lord, I am supporting the petitioner.
But it has to
You also come up with judgments the
My lord,
last week's
my lord, I
judgment.
have given two examples that hockey trap. In respect of the hockey trap, with custom first disputed by the side, thereafter it has cleared. I have given that example.
Very well. When do I keep it? I'll deliver the part judgment on the next day. When?
Tuesday, my lord.
No, not Tuesday. I'll keep it next Friday. Friday is better. I have fixing up other matters on those dates.
Can it be on any other day except Friday?
Why? The list of the court is too congested to grant accommodation to anybody.
It will not take much time.
2 o'clock Friday.
Friday, my lord? Friday date?
Friday, it's 24th. Oh, you are not there.
I will not be there.
You are not there.
I will not be there.
31st?
31st time.
31st fortnight.
31st.
It is a Friday.
I have to see the color of money. Every day is convenient to me.
Yes.
31st, my lord. All right.
You can join virtually also. There is no issues. This court permits virtual hearings. It is a little bit convenient because other matters are too packed up on the rest of the days.
Friday week.
Friday week.
My lord.
Acha. Post the matter on 31st of January 2025. Stop learned advocates representing the respective parties shall come prepared with the precedents in this regard.
Yes. ABL is with me. I'll get the recent ones also.
Yes, yes.
16, I am for the petitioner, my lord.
Yes, sir.
On the last occasion, there is a direction. I am for the petitioner, my lord.
Yes.
Permit me to file a position, lordship, regarding.
May I have the copy of
Yes,
the
yes, yes,
petition, my
yes,
lord?
yes, yes.
The matter is, my lord, I'm pursuing in my internship from Manipal University. I'm passed out student in Bachelor of Dental Surgery, my lord, under the scheme of West Bengal Student Credit Card.
Can extra loan be granted?
No, your lordship.
No, why?
Lordship, kindly come to page number 17 of their application. Page number 11. Page number 11 of their application, your lordship.
Yes. 11 is his
Aadhaar card.
We request for a loan of rupees 5,64,000.
Page 11 is the Aadhaar card.
Lordship.
Page 11 of the writ petition.
Lordship, page 11 of my opposition. Lordship, I have
opposition.
Opposition.
Page 11 is
Opposition. Their
Yes,
application,
yes.
your lordship.
Hmm.
They have demanded only 5,64,000 before the bank, and thereafter, your lordship, kindly see page number 17, your lordship. To page number 17. Term fee, tuition fees 24 lakhs 56 something, and thereafter, your lordship, total into 24. Thereafter, your lordship, amount of loan required from the bank, lordship, 5,64,000.
Now he says that the course fee has increased.
Lordship, if the another situation has been taken place, then he has right to file a fresh application before the bank.
That has been filed. That has been filed.
Lordship, regarding they have demanded this. Loan application has not been, as because when the entire loan amount has not been recalled, the fresh loan amount has not been issued.
Would you like the student to stop the education over here?
Lordship, no. Lordship, if the
Find out a solution. What is to be done?
Lordship,
the student will not be in a position to pursue his career.
Declaration is I have only required this amount, and the entire amount, all the amounts has been paid by the petitioner
Absolutely all right. On the day the loan application was made and it was granted, this was the condition.
Lordship.
Now the condition has changed. The course fee has been enhanced.
Then if fresh loan application, here two questions are there. First question is here.
I do not want to know the question. I want a solution. What will you solve? What is the solution that you can provide?
Lordship, as this SS Bank is unable to provide the loan in that account, your Lordship.
Any other account?
And any other, then separate loan application, he has to file, he has to submit a separate loan application.
He is a student and he wants student loan.
In this
education loan.
Lordship, she is demanded, petitioner is demanded in this loan application. It is not be possible for
you are here to find out a solution and not to create any confusion in the mind of the student.
Lordship, this is not the confusion has been raised by the respondent bank is in this case, your Lordship.
The petitioner is a problem. How do you solve it? I do not want to know anything else. Please find out a solution. What is to be done? The student is cannot pursue his studies.
Lordship,
and his examination is going to start next week.
Examination has been completed. Entire result has been passed out. And thereafter, the 2024 is the generally, your Lordship, regarding.
Where is your exam schedule?
31st of January.
Show it to your learned senior friend.
On 31st January, NEET MDS examination will be held. My lord, may I indicate one thing, my lord? My lord, my application is on page 28 and another legal notice in page 31.
Is it a new course that you are pursuing?
No, my lord.
It is the same course. How can the course fee be enhanced in the midst of the course?
No. The thing is that while I was applying the initially, there is a dispute between the students of the academic year of 2018 and the Manipal University, and one litigation is pending before Honorable High Court at Karnataka. At that point of time, 20% of the course fee was reduced for the time being. So I obtained a loan of 5,64,000. Subsequently, the university obtained favorable order from in the said litigation, and they compelled me to deposit the rest of that 25% of the course fee, my lord. Same course fee.
Where is the order of the Karnataka High Court relying on which the university is doing this thing?
My lord, page 17.
Page 17.
This is not the order, but this is the correspondence of the university, my lord. May I read out?
But this is the email dated June 22 and May 23. We are in 25. Why have you approached this court at such a delayed point of time?
My lord.
31st is your examination.
Yes, my lord. My lord, my representation was made. My lord, kindly consider page 26. The correspondence from the university dated 26th of March 2024.
Page 26, yes, 26 March 24.
Yes, 4,60,500 is due for the academic year AI 2022 and 23.
Yes.
Thereafter, my lord, page 28, I served correspondence to the bank. 8th April 2024, this correspondence, my lord.
And you are approaching this court after nearly 8 months?
My lord, in between this time, naturally, I was waiting for the reply of the bank, but
in that case, you keep waiting and you sit for the examination next year?
Not at all, my lord.
You are in problem.
My
you should approach court in proper time. You know the proceedings in courts take time.
I seek
it's
mercy.
Not that overnight you'll get a result.
My lord. I seek mercy.
The bank is facing problem in giving further loan to you on account of non-payment of the earlier loan amount.
May I indicate one thing, my lord?
Yes.
With regard to the gadget of West Bengal student credit card scheme, my lord. In the criteria clauses, my lord, there is no such clauses that yes, I have not repaid the earlier loan, but there is no bar from me. I will face the consequences. I will not be able to repay the loan, but there is no bar for.
How will the bank recover the amount from you?
This is a co-borrower, my lord. My father is the co-borrower. In that event, if liberty is granted, my mother will be the co-borrower, my lord. And the only condition is after completion of the course fee or after getting job, I will repay. But the difficulty is, my lord, until and unless I will pay the actual difficulty, my lord, until and unless I will pay this balance 25% of the course fee, I will not get the provisional certificate.
Yes, how can you?
And
Till
if
you
I
make payment.
So for that reason, my lord, I need this additional loan, my lord. Either
Mr. Jha,
Lord,
take it as
kindly see one.
I will not look at
enhancement or
anything.
another.
I will not look at anything. Don't take this as an adversarial litigation. A student is in problem. She is pursuing her medical course. See if anything can be done so that she does not lose a year and the problem can be resolved.
Lordship,
Don't tell me anything.
Lordship,
I will
kindly
not look
consider page
into
number
it.
26, which my friend has submitted before you, Lordship. Page number 26. Lordship, total course fee 24 lakhs 56,000 here. Lordship, total course fee. Here, your Lordship, page number 14. Page number page number 14 of their read petition, your Lordship. Total course fees 24 lakhs 56,000. On contribution, your Lordship, 18 lakhs 92,000. Their declaration, their read petition, your Lordship. And thereafter, your Lordship, as per their application before the bank, your Lordship.
As per their application, you have paid money. There is no issue. But thereafter, an order has come from the court pursuant to which the university has raised the amount.
Lordship, nothing, your Lordship. 24. Lordship, total course fee 24 lakhs 56,000.
You
Lordship,
say the course
page number
fee has
20
not increased.
Lordship, kindly see the documents submitted by the.
Why is the petitioner seeking extra money?
Lordship, 24 lakhs 56,000. Kindly see, your Lordship, page number 26.
Why is the petitioner seeking?
And thereafter, their statement, 18 lakhs 92,000. His contribution, Lordship, he has not paid his contribution before the university, your Lordship. He has not paid 18 lakhs something, your Lordship.
It is you who pays it directly to the university, isn't it?
Lordship, as this stage, it is not be possible me to pay the university this amount, as because this amount has not been sanctioned. Only that amount has been sanctioned which they have applied.
No, my lord. If I will not use the money for my study purpose,
you have not.
One second, sir. 1 second, sir. While applying for the loan, I have to produce relevant documents before the bank authority.
If the money is transferred from the bank directly to the university, isn't it?
No, to my account.
To your account, and then you pay it.
Yes, yes.
Did you pay the money which was given by the bank to you for the education purpose? Has the money been paid?
Lordship, 18 lakhs 92,000
Initial
has not
amount
been
has
paid
been
by the
initial.
1 minute. How much money did the bank as on date give to the petitioner?
At this stage, not a single price bank will pay.
No. From the date of taking the loan, how much money did the bank give to the petitioner?
As per their requirement, they have submitted before 5,64,000.
You have disbursed?
Yes, your Lordship.
564 you have disbursed. Did you pay 564 to the university?
Yes, that has been paid.
And thereafter, his contribution amount is 18 lakhs 92,000. She is not paid 18 lakhs 92,000 before the.
What about your contribution? Did you pay it?
No.
No.
He has not paid.
You have taken
her contribution.
loan for a particular portion.
Particular motion.
The rest you are to pay. Did you pay that?
No.
18 lakhs.
Yeah, has been paid. The rest of the course fees have been paid.
Then
in own contribution 18 lakhs then interest?
Yeah, it has been
Yes,
paid.
it has been paid.
Lordship, then here they are into 26 May to 2024. Lordship, here 24 lakhs 56,000. that amount will demanded by the university.
Mr. Jha,
Lord.
please, a request from the court. Don't take this to be an adversarial litigation. See that the candidate can conclude the course. Whatever is required to be done, please do it. It should not be taken as an adversarial litigation. Do you get it? 31st is the date of the examination. It starts. Whatever is required to be done, intimate the advocate concerned and let the student prepare her studies, and the parents will follow it up with the bank.
Then the parents has right to approach before the bank a fresh loan.
It is the student's loan. How many students' loan will be allowed?
Lordship, allow me 1 minute time. Lordship, if the petitioner's concern is there that the 10 lakhs welfare fund West Bengal education loan amount is 10 lakhs, she has not applied before the bank for 10 lakhs.
If she does not require 10 lakh, why will the application be made for 10 lakh?
At this stage, Lordship, it is not be possible to the bank.
Whatever is required to be done, please do it. Please come. Affidavit in opposition filed by the respondent number 2 is taken on record. Stop. Paragraph. The bank is directed to take all necessary measures to ensure that the loan amount required for the enhanced course fee can be made available to the petitioner. Stop. The examination of the petitioner starts from 31st of January 2024. Stop. The bank is directed to take up the matter on urgent basis and file an affidavit of compliance before this court on 24th, next Friday. I'm keeping it. I will not hear anything from you. It has to be done.
May I file the gadget of the scheme, my lord?
Do everything, whatever you've got to do with the bank, and Mr. Jha is there.
Lordship, so far my knowledge, when the
even out of knowledge, many things can be done. Please do.
Grateful, my lord.
If the banks not be then, Lordship, and nothing.
Victor, appear for the petitioner. In this matter, that demurrer question was raised by my learned senior friend regarding maintainability, one, and if I have understood correctly, and also forum shopping. He'll have to address on that, I believe, first, if it is a demurrer point. Otherwise, I can start.
Yes, if a point of demurrer has been taken, you have to meet it first. What is the issue? Tell me once.
But kindly see the first of all the prayer portion.
Yes.
The issue is
what is the prayer? On the last occasion, your lordship was pleased to, it has fallen from your lordship that whether the consumer forum has got the jurisdiction to decide on the matter. But this is not the case before your lordship. But since it has fallen from your lordship, I will show to your lordship aspect, because this is the most important aspect and it will come several times.
It is a maintainability issue, I believe. A maintainability issue, I believe.
Let me complete. Please take your seat. Let me complete.
The demurrer point is the writ petition is not maintainable.
Not maintainable. Why?
And
Because kindly see the first of all the prayer portion.
Yes.
This is the mandamus. First prayer is an order passed quashing or setting aside the bill generated for the period from January 2020 to March 2021. Lordship got that? Now Lordship kindly come to, now here at the first instant, this is my duty to bring to your Lordship kind notice that at the initial stage, my learned friend's client has raised a dispute pertaining to the electric bill. Now thereafter, a check meter has been given and it has been recorded and it is deemed to be the correct, and as per the statutory provision, it can be done. What has been fallen from my learned friend that it should be given to the government authority for testing. Now what happened during that time, my learned friend, there are two avenues open. Your lordship knows if there is any billing dispute, one can go before the GRO under the regulation 56 as per the Electricity Act, and as well as since there is a deficiency of service, your lordship knows in a consumer forum when pertaining to defective goods, another pertaining to deficiency service, one can petitioner approach the consumer forum. Now kindly see the order passed by the consumer forum for a moment. I have to read the entire order, otherwise it will be.
Why? Entire order?
Yes, what happened? Whatever the contention is there.
Same contention
Same
is over here.
contention. And I
Alright.
will show you that from January 2020 onwards, he has challenged that bill, and on that basis, it has been observed by this learned forum, there is no deficiency of service and the bill raised is the correct bill.
All right.
And
Now,
subsequently,
I have got your point.
and
Now
then
let me
again, he
fix.
has challenged before the State Consumer Forum.
They're also
They are
lost.
upheld. And as per the Consumer Protection Act, it is my duty to bring to your lordship kind notice under section. Kindly see section 58.
Yes. The National Commission.
Yes. Now, from the State Commission, he can prefer an appeal before the National Commission under section 58, lordship. 58.3.
No. This is not to be
Yes.
shown. Yes.
So on that basis, on same, they never challenge
Yes, I
that
have
order.
followed your submissions.
But if I have understood correctly, there are 2 points involved in the demur question. One is maintainability, which should be entertainability, because the petition is maintainable in any case. Whether this petition should be entertained on the basis of the fact that I have approached the consumer forum, or whether the consumer forum creates a bar, or does it provide an alternative remedy? That is the question. And the second question is forum shopping, which he had uttered on the last occasion. Today has not addressed on that, but forum shopping I'll also address before lordship. But forum shopping, in my humble submission, would be on merits, not on the demur question. Now, if your lordship kindly takes up the Consumer Protection Act, it's before your lordship. Now, the question as to whether I should approach from the State Commission to the National Commission is not before here, because I am not challenging the order of the State Commission. What I'm challenging here is a lack of duty, a duty which is cast upon under the statute has not been followed. That is my contention before your lordship. Now, if your lordship kindly sees the Consumer Protection Act, what I can agitate before the Consumer Protection Act. If your lordship, I'll have to address before lordship on the power of the Consumer Protection Act, power of the Consumer Forum, as well as what are the services, what are the scope of challenge under the
Will you
Consumer
please
Protection
show the order passed by the forum?
Yes.
Let me start from there then. The order passed by the forum. It's my lord.
You have annexed the petition before
Yes,
the
I have.
forum?
There is no separation.
Yes, please show me once.
My lord, the order of the Consumer Forum, the Learned District Forum, is, my lord, at page. Kindly give me a moment. Just
Page 78. Page 75.
Yes, it starts from page 75, and my petition is just before that. If your lordship kindly allows me, no, 75 is the order of the district forum. If your lordship kindly allows me to place the petition first before the consumer forum, what I went for. If my lord kindly takes the page 44 first. Page 44 is my petition before the Learned District Forum. And this is a translated copy from Bengali to English.
Yes.
And if your lordship now kindly comes to page 45 to look at my prayers, your lordship will kindly find my prayers at the bottom of page 45, prayers of the petitioner. Lord, prayer A, ordering that the counterparty may pay the 18 installments. Lord, kindly do not go into the language. The sum substance of prayer A is that I am seeking for, my lord, distribution of the amount payable into 18 monthly installments.
That means you admit the amount that has been.
I have not. I'll show from records. I have not.
Your prayer suggests that you have.
That's why, my lord, I said, my lord, in the very first instance, this is a translate copy from English, which is not a very good translation. And my lord, it appears from here that it is 18 installments, but my lord may kindly not rely on the exact language used here.
Even if you do not rely, the moment you say that you permit me installments to clear off the dues means that
I have
you
admitted,
admit
yes.
the dues.
That will mean so if your lordship kindly reads on 18 installments after proper inspection of the electric bill meter. That is what the, my lord, this hazy translation from Bengali to English also say. But 18 installments after proper inspection. Because there are documents prior to this which says, my lord, I have clearly raised disputes and I have clearly sought for, my lord, proper inspection. And my lord, this test meter also was brought in before that. So, my lord, 18 installments after, my lord, inspection. That is my first prayer, the sum and substance of it. 2 is, my lord, to issue an order to the opponent that the opponent may not disconnect. Not to disconnect. That is a prayer I have made as prayer B.
at page 46. Prayer C is, my lord, for compensation, and prayer D is also, my lord, for compensation. It is not properly worded, and this, my lord, could not be understood by me. So prayer C for compensation, prayer B for, my lord, an injunction from disconnection, and prayer A, my lord, first inspection, then, my lord, distribution in 18 equal monthly installments. This is the sum and substance. This is the scope with which I went before the London District Forum. Now, if your lordship kindly takes up the statute, District Forum has refused my prayers. Where this prayer B, my humble submission is, even couldn't be, my lord, placed. This prayer B, where I seek for an injunction from disconnection, this could not be made before the London District Forum.
Hospital. Inspection.
বলছি মেরিট স্যার ওটাই বলবো। বলছি
The forum has decided on the basis of the documents and the evidences that has been placed before it that you are a habitual defaulter.
Has held.
You avoid payment. You are causing loss to the public exchequer. There is no deficiency in service or negligent act on the part of the OP.
Yes.
Right?
That has
What
been held by the
remains?
District Forum.
What
May I
remains?
show, my lord, that is why I went before the State Commission, and there is the scope. If this observation still remains, I'll have to, my lord, carry this to the National Commission as well, because
Yes.
these are completely unsubstantiated. I am
Then it's
held to
better
be
you
habitual
take it up to
defaulter.
the National Commission.
I am not on this issue before your lordship. That is not the issue agitated before lordship. Now your lordship kindly sees my prayers in the writ petition. Lord, prayer B, as I was trying to show before lordship, that before the District Forum, it couldn't be maintained. Prayer B, seeking injunction from disconnection. And that is principally my prayer before this honorable court.
You will not make payment, and
I
the
will make
writ
payment.
court
I am ready and
will
willing.
come in your favor
My lord, I am ready
and
and willing.
injunct the authority
I am ready
from
and willing.
disconnecting
May I
supply.
just submit? I am
That's
ready
why I
and
prefer
willing.
the cost.
I am ready and willing, provided the law is followed. If your lordship kindly takes up the statute, what is the duty of the electricity authority in this case? What is the duty of the licensing
What
authority?
is your duty? To
Not payment,
consume
not
electricity
making payment,
without making
not
payment.
making payment.
Yes.
But the bill is
From
not raised properly.
2018, payments are not being made.
No, that is not the case. But the
From
payment is not made
2020.
from 2020 COVID period up to 21st, up to March 2021.
Very well. From 20 to 21.
Yes.
This
The
is
bill has-
25.
Yes, I'm telling, my lord, the bill has come in 21. The bill has come for the first time in March 2021 for an amount of 6,67,000 and odd. That is the bill which has come on 21st after in March 21. After, my lord, all this period of 1 year 3 months. That is the bill that comes to me for the first time.
State Commission Order, page
May I
130.
conclude? May I conclude? Yes. State Commission order is there. I'll place everything. That is on merits. I'll place everything. The bill has come to me. If your lordship kindly takes up the bills.
A test meter is installed. The test meter says the readings are correct.
If your
and
lordship
even
kindly
then,
takes up the test meter,
according to you,
my
it
lord
is
kindly comes to the
incorrect.
test meter. My lord kindly comes to the test meter. Kindly comes to the readings of the test meter. But I was placing on the last day. I started from there on the last day. My lord, page 36.
Can it be reopened here when it has
May I-
already
may I
been
make a
attained finality?
But may I make a comprehensive submission before, my lord, I'm interrupted? My lord, if your lordship kindly takes up page 31, that is the bill. Page 31 is the bill. Your lordship will find the billing date of 9/3/2021. Your lordship will kindly find at page 32 the billing amount. Page 32, the billing amount comes to 6,67,000 and the period, my lord, you'll find from here only. But the period is for the entire period of 1 year, 3 months. And I have shown before your lordship that not the yes. May I again show before your lordship, page 36. Your lordship will find a number of rewritings on this bill. This is the bill, this is the test meter, this is the reading of the test meter. A number of rewritings with signatures. I have stated, I have pleaded in my petition, signatures from the officers and all persons, agents, who had come to erect this bill, to install this bill. Your lordship will find that there are a number of writing offs and then again rewritings to adjust it with the same, reconcile with the same, it with the next reading.
Assuming that page 36 you are aggrieved, right?
My lord.
Page 37 there is a certificate that the meter is okay.
Yes.
Did you raise any grievance before the grievance redressal officer?
Next page. Kindly turn to the next page. 26/3/2021, page 37 is the date when WBSDCL say that the meter is all right.
Yes.
The very next day, 27/3/2021, page 38.
Yes.
I will categorically point out
No, the station manager is not the competent authority. There is a grievance redressal officer.
Manager. I have indicated this on the very next day, thereafter, to the area and station manager.
He is not the competent authority.
And my lord, also to the assistant engineer of the station manager.
But you did not write to the grievance redressal officer. You write to all other parties. You approach the state commission. The
state that I have written, but it is not here, and it is not annexed here. Of that period only. Thereafter, I went to the district commission.
Yes. So it's directly.
District forum. So may I complete my submissions?
No, I have followed.
I have more to show. I have more to show. If your lordship kindly takes
I am paying for some cost.
If I may show the statute, what is the duty imposed? What is the duty cast upon the authorities?
The
may I be permitted to show this? And one more thing. If your lordship kindly before starts me off.
The bills.
This period, if your lordship kindly.
WBSDCL.
Your lordship will kindly hear me on this.
Stop next.
Will kindly hear me on this. I was not in use of the hospital also. The hospital was taken over by the state government and it was released in my favor only in June 2021 after the bill was raised.
It appears that that being aggrieved by the meter readings, the petitioner approached the WBSDCL and one test meter. What is it called? Challenge meter.
It is a challenge meter.
And as per provision of 3.5.8.
Challenge meter was installed.
As per the statutory provision.
To check as to whether the meter readings were correctly recorded or not. Stop. By a communication dated 26th March 2021, the petitioner was informed that the meter reading was okay and there was outstanding dues lying in respect of the consumer in question. Stop. Being dissatisfied, the petitioner filed representation before the station manager and before the assistant engineer. Stop. As there was no positive response from the end of the authority, the petitioner approached the Consumer Disputes Redressal Commission, Uttar Dinajpur, which rejected the claim of the petitioner by passing an order on 18th of August 2023, which was taken up in appeal by the petitioner before the appellate forum.
State
Commission.
Being the state commission, and the state commission also dismissed the appeal filed by the petitioner. Stop. Paragraph. Now the present writ petition has been filed. আচ্ছা এই অ্যাপিলের অর্ডারের ডেটটা হচ্ছে date is 30th August 24. The present writ petition has been filed by the petitioner alleging that the respondent authorities did not perform duty in terms of the statutory provision. Stop. Paragraph. prayer has been made to restrain the licensee company from disconnecting the electric supply. Paragraph. The learned counsel representing WBSEDCL submits that the writ petition is liable to be dismissed with exemplary costs. Stop. The petitioner the petitioner only with the view to not make payment in terms of the bill that has been raised is moving from one forum to the other. Stop. Paragraph. It has been submitted that as the petitioner has already approached the approached the forum under the Consumer Protection Act, 2019, the petitioner has an alternative remedy of appeal before the National Commission. Stop. Paragraph. I have heard the submission made on behalf of the parties and have perused the materials on record. Stop. It appears that being dissatisfied with the bills raised by the company, the petitioner approached the forum and thereafter approached the district forum and thereafter the state commission. Stop. The petitioner never approached the GRO.
Yes.
The
under
form?
regulation 56, grievance redressal officer.
Redressal officer under regulation
56.
Stop. At this stage, it is not possible for the writ court to revisit or reopen the issue all over again. Stop. Paragraph. It will be open for the petitioner to approach the competent forum for remedy.
I submit that it is barred by res judicata, because now at this stage, when it has already been decided, now they cannot reopen this point until and unless it can prefer an appeal.
Not
But then they will take the undue advantage and they will then approach before the GRO.
I have not disclosed the forum.
Lordship.
Where to go?
I'm deeply honest.
If he goes to the GRO, the GRO can deal it in his way.
I got you. May I take back the book?
Yes, certainly.
My lord, number 21, lordship, on last occasion was pleased to fix it, my lord. And my lord, we have agitated before the DRT, my lord, and the DRT has granted stay and intervention application is allowed.
So this writ petition can be disposed of.
And my lord, it can be disposed of, my lord.
Yes, please
My
come.
lord, I'm
21, who is the other side? The writ petition is being disposed of? Writ petition is being disposed of?
Because the Olisa has obtained interim order.
Please come. Look into item number 21.
My lord, the matter is fixed for 18th of March, my lord.
It has been brought to the knowledge of the court that the petitioners have already approached the Debts Recovery Tribunal for relief, and the tribunal has taken up the issue for consideration. Stop. In view of the above, there is no requirement of proceeding with the writ petition any further. The same stands disposed of.
Deeply grateful, deeply obliged.